All the articles for free. Thanks to the George M. Yeager Family Foundation, whose generosity allows us to hold this symposium and publish this journal. This year is unusual in that our Constitution Day during the COVID-19 pandemic at vocations that allow relatively uninterrupted remote work have had to adjust to a new way of doing business, and that includes the Supreme Court. After canceling the March and April oral arguments, the court set a rare May argument session, while also pushing a dozen cases into next term. Today is the day when we review the Supreme Court term just passed and preview the next one, finishing up with the annual B. Ken Assignment Lecture, which this year will be given by Judge Don Willett of the U.S. Court of Appeals for the Fifth Circuit. After that, we've had to forego our traditional rooftop reception, but you're welcome to treat yourself from your own liquor cabinet. We hold this event on September 17th because on this day, 233 years ago, the framers completed the Constitution in Philadelphia and sent it to the states for ratification. Liberty through limited government animated the Declaration of Independence, while the Constitution set out to make a more perfect union that would better secure and protect liberty. Later, we saw what's called the completion of the Constitution in the second founding of the post-Civil War amendments, though that was largely thwarted by a Supreme Court unwilling to defend individual rights against state violation. Then, after a rebirth of economic liberty in the Lochner era, we had a constitutional reworking without amendment during the New Deal. The critique of that inversion has animated our center, and you can read about that dynamic in my new book, Supreme Disorder: Judicial Nominations and the Politics of America's Highest Court, which will officially be released on Tuesday, but is now available for pre-order on Amazon and elsewhere. To give an overview of the conference, let me introduce the man largely responsible for putting it together, Trevor Burrus. Trevor is a research fellow in the Levy Center and editor-in-chief of the Cato Supreme Court Review. He's also the editor of two books, A Conspiracy Against Obamacare and Deep Commitments, The Past, Present, and Future of Religious Liberty. And he co-hosts Free Thoughts, a weekly podcast that covers libertarian theory, history, and philosophy. Trevor first came to Cato as an intern right after graduating from the University of Denver Sturm College of Law a decade ago, and he's stuck around ever since. I'll now turn the program over to him, but we'll return at the end of the day to introduce Judge Willett. Welcome.
Thank you very much, Ilya, and welcome to the most normal Constitution Day ever. I am Trevor Burrus, editor-in-chief, honored to be editor-in-chief of the Supreme Court Review. This year, I had to get a printer and sit here at my kitchen table and furiously edit these articles, which we publish very quickly, as our authors know. Some of our authors were under even a higher time pressure than they had been in the past when the Supreme Court continued its decisions until July 9th. So I thank our authors for producing work so quickly. Now, although law professors can be long-winded, apparently lockdown contributes to it also. So although I don't yet have the book in hand, it is sitting in boxes, shipping boxes at Cato HQ at 380 pages. While it's not our longest issue ever, it is the highest in terms of average length per article. The book is live on our website today. You can download the articles and read them as you watch the panels. But for a few opening remarks about the Constitution itself in this extraordinary time, every year it seems that we must say, today the Constitution is more important than ever. This year, however, that seems particularly true. Our nation has not seen an upheaval like this in our lifetimes. Into our already politically schismatic tinderbox, we've added wildfires and riots and, of course, a deadly virus. On the 2016 election day, I was in Athens, and it was glorious. I vowed then to be out of the country for every presidential election. Now I can hardly go anywhere legally, but I'm thinking on election day of finding a cabin in my home state of Colorado with provisions and plenty of ammo. Why are we here, aside from the exogenous factors of fires and viruses? Never have I been more convinced that constitutional corruption is one of the most important inputs into our cataclysmic political culture. While our Bill of Rights is largely stronger than ever, the essential aspects of constitutional structure, those guardrails that were debated for 4 months in Philadelphia in 1787, remember where they did not really discuss a Bill of Rights except for in the last week to vote it down. Those guardrails have never been more shaky. Therefore, we have turned into a system where the presidency is almost all that matters, and so many people in each party view the election as an existential threat. Of all the things that would most surprise the framers, and I don't think Donald Trump would be one of them because he is exactly a type of person that they feared could become president, but I think it would be that Congress gave away and continues to give away its power. Congress is created in Article 1 because the framers think that it was first among equals in our branches of government. Congress would jealously guard its power, they believed, and not willingly give the executive too much authority. That, of course, did not happen. Public choice scholars and political theorists can explain why, but it was hardly foreseen. Now Congress has basically been a do-nothing body for more than a decade, and maybe 2 decades. The presidency has become the focal point of policymaking and policy change in the government. Who the president is matters now more than ever. Too many times when presidents act with sweeping unilateral authority, legal scholars go and look at the law and say, wow, Congress gave the president tons of discretion. I know I've done that many times during especially the last 2 presidencies. President Trump imposed steel tariffs by claiming that they're in the interests of national security. While the Constitution explicitly gives Congress the power to regulate commerce with foreign nations, the Trade Expansion Act of 1962 delegated a significant amount of that power to the president by allowing him to unilaterally regulate foreign commerce in the interests of national security. The Obama administration purported to redefine the concept of gender when it came to public school bathrooms by publishing a Dear Colleague letter instructing schools to let students use the bathroom of their gender identity. Now, as a strong supporter of transgender rights, I was nevertheless shocked the administration would so casually force such a broad social change. Transgender rights and issues of bathrooms are the type of issue that should be debated in Congress, not imposed by the president. And of course, when the president does such a thing, as President Trump did, you can get administrative whiplash, to use a phrase from an article on Little Sisters of the Poor by Robin Fretwell Wilson and Tanner Bean. Administrative whiplash is when the president is making all the policy and you go back and forth as they rescind and pass regulations with each election. So Congress doesn't work, and we're left with a president who has powers that even King George III didn't have. Under current law, an opposing president, a president can switch significant environmental regulations, impose national emergencies to solve pet projects. That's a new one that's come around. Radically restructure immigration, significantly alter regulations on businesses, and even fight undeclared wars, all without asking Congress to do anything. And I've come to the conclusion, as more so this year than ever, this is no way to run a constitutional republic. The Cato Supreme Court review and this event and the Robert A. Levy Center for Constitutional Studies exist to remind people of the fundamental principles of constitutional governance. Although it's become cliche, it's more important now than ever. I'd like to thank those who gave invaluable help with putting together the review. First, the authors, as I said, who did an excellent job. Thank you for putting up with my edits and protestations, and I think all of the articles came out great. Ilya Shapiro, of course, for being an excellent director of the department and a great articles editor himself, and of course, the legendary Roger Pilon, who started our department and gave it its mission and vision. He is also a great articles editor. Robert Levy, chairman of the Cato Institute, and the namesake of our department. He also likes to get his hands dirty with editing articles. Clark Neely, Jay Schweikert, Walter Olson, and Will Yateman were also excellent articles editors. Legal associates Michael Collins, Dennis Garcia, James Knight, Christian Townsend, and Mallory Reeder provided valuable editing, site checking, and proofreading. And of course, legal interns Brandon Bayer, Wen Tao Zai, and Joao Barbarossa did similar proofreading and editing. And finally, Sam Spiegelman, who is indispensable in this process. Hard for me to say how much he's done with editing the articles, and it would be hard to do this without him. In the 2 years I've been doing this, he's been indispensable. Thank you very much for attending our event. We can move into the first panel as we get into set this up. Bear with us here as we deal with some of the logistics of this. First panel, being a little bit early here, but I will invent. This is our executive branch and constitutional structure panel, which I think is important for the reasons I previously stated in my introduction. We will discuss the relationship of president to Congress. We will discuss the relationships of president to agency heads for so-called fourth branch of government. And we will discuss the relationship of president and immigration law. I will introduce our panelists first. If you go to the Constitution Day page, their full bios are on the contributors link at the bottom, so I will give brief introductions for them. First, on the subpoena cases, we'll have Jonathan H. Adler, the inaugural Johann Verhey Memorial Professor of Law and Director of the Coleman P. Burke Center for Environmental Law at Case Western Reserve University School of Law. Next, we'll have Elon Werman. He's an associate professor at Sandra Day O'Connor College of Law at Arizona State University, where he teaches administrative law and constitutional law. He will be discussing the Seila Law case. And finally, we'll have Peter Margulies, a professor of law at Roger Williams University School of Law in Bristol, Rhode Island, where he teaches immigration law, national security law, and professional responsibility. He will be discussing the DACA cases. So without further ado, I will turn it over to Jonathan Adler to discuss the subpoena cases. John?
Great. Well, it's a pleasure to be here. Too bad we can't be there in person. I will be sure to send Ilya a bill for my bar tab later this evening. But it's a pleasure to be here, in particular to talk about the financial records cases. These are fascinating cases that I think, and as I suggest in my paper, could only have been brought to us by the combination of having a Trump administration and with the particular connections and entanglements that President Trump has, combined with the hyper-partisan environment that we find ourselves in today. And these cases, as a general matter, concerned whether the president and by extension his family and his businesses were immune from demands for their financial records from third parties. A lot of people talk about these cases as being about tax returns. They're really about financial records more broadly, all sorts of financial records of Donald Trump in his personal capacity, his direct relatives, and a range of Trump-related businesses were involved in these cases. As I've already noted, I think to understand what was going on in these cases, why the Supreme Court was dragged into these cases, it is important to recognize the context. With Donald Trump, we have a president that has a range and degree of financial entanglements that we have not seen in the modern era. His involvement in the commercial real estate industry in New York, in the international hotel and conference industry, led to a degree of connections, business relationships, and the like, not only with entities here in the United States, but also with foreign entities, foreign governments, and foreign individuals, raising a wide range of concerns about potential conflicts of interest. Combined with that, I think it is fair to say that President Trump has been subject to a range of allegations concerning financial and other improprieties that, again, really have no precedent in the modern era. Claims of altering or disguising or misrepresenting financial records for various purposes, claims also of various other personal improprieties, and a range of lawsuits against him in his personal capacity. Another factor is less disclosure. I know Senator Johnson said this week that no president has been as transparent as Donald Trump. I think anyone who actually looks recognizes that that is an absurd claim. The first president in 50 years not to disclose his tax returns, and a White House that in general has been more resistant to oversight and disclosure than any recent predecessors in the modern era. As I also noticed, we have a hyper-partisan environment. It seems that everything is about Donald Trump all the time, and I think it is fair to note that there has been a degree of partisanship in Congress and among state attorneys general, trends that certainly predated Trump coming into office, but that have continued, which led to the sorts of document demands that ultimately led to these court cases and these cases reaching the Supreme Court. I think most people are aware of the general details of these cases. I don't think I have to give a ton of background. One case, Trump versus Vance, involved a criminal subpoena filed by the New York District Attorney, a grand jury subpoena, so seeking documents that would be confidentially held and examined by the grand jury in its consideration of potential indictments of possibly Donald Trump, but certainly possibly family members, business entities that he is involved in, a wide range of possible investigations that are clearly within the jurisdiction of the New York grand jury. The second case is really a combination of cases, all involving various congressional subpoenas for financial records. One that came out of the DC circuit, that is the Mazars case for Trump versus Mazars, but in addition, some congressional subpoenas that were considered by the Second Circuit in the Deutsche Bank case. One thing that's also distinct about both sets of cases is that these were not subpoenas filed directly against the president himself. These were not subpoenas filed to Donald Trump as president, Donald Trump as a private citizen. These were all subpoenas directed against third parties that have these documents. So subpoenas were filed against Trump's accountants, the Mazars, and also filed against banks that have various financial records. And at least in the congressional cases, I think that's potentially quite significant. Of the two decisions, I should say both decisions came out the last day of the term, well into July, both written by the Chief Justice, both in their broad sweep were 7-2, in the sense that in both cases, broad majorities of the court rejected the extremely broad claims of immunity that had been asserted on behalf of Donald Trump. There was some disagreement on the particulars in the Vance case, but both cases, I think, were fairly broad and profound rejections of the claims of immunity that Trump had put forward. Of the two cases, I think the Vance case is more straightforward in that here you had a grand jury seeking to obtain documents for the purposes of investigating of potential crimes under state law. There is some question about whether the grand jury could issue an indictment against Donald Trump himself. But I think it was pretty well established going in that the grand jury can investigate businesses related to the president, can investigate individuals that are in business relationships with the president. And it seems, I think, fairly straightforward that they therefore can also investigate the president. And from the very first sentence of the Chief Justice's opinion in this case, it was very clear how the court was going to come out. The court, Chief Justice Roberts noted at the outset that in our judicial system, the public has a right to every man's evidence. Since the earliest days of our republic, every man has included the President of the United States. For you Hamilton fans out there, lots of references to founding era investigations, including those related to the Burr trial. But also the court noted that as recently as the Clinton administration, the Supreme Court had rejected broad claims of immunity by a sitting president against court proceedings that were based on actions that the president took in his private capacity prior to taking office. In Clinton versus Jones, the question was immunity for civil suit in federal court. The Trump attorneys tried to argue that we should treat this differently, perhaps because it's criminal, perhaps because these are state court proceedings, but the court rejected that. There was no reason the court could see why any sort of blanket immunity could be offered. While it is certainly conceivable or possible that state court proceedings could interfere with the president's ability to perform his duties, that would need to be shown. No blanket claim of immunity could be recognized. Further, the court said that there was no basis for any heightened standard for issuance of a criminal subpoena for the president's documents. 5 justices, the four liberal justices and Justice Roberts joined his opinion. Justices Kavanaugh and Gorsuch concurred in the judgment, but held separately that they thought a slightly more demanding standard was appropriate. But I think it's important that they joined the judgment of the court, affirming the Second Circuit's rejection of any immunity claims. The Chief Justice and the Gorsuch and Kavanaugh opinion recognized that, like any other litigant seeking to dispute a subpoena, Trump would retain the ability to raise specific arguments about specific document requests on remand, but that any claims of immunity would not be recognized. Now, in terms of the congressional cases, I think these are the more interesting cases. I want to spend the balance of my time talking about these other cases. I think these are the cases that going forward, I think are the most interesting, and I think that these cases really are the most significant in terms of what they tell us about the balance of power between Congress and the executive branch. Here, like in the Vance case, Congress had sought documents from third parties, from Mazars, because Mazars, as Trump's accountant, has the various financial records. This is important, as Chief Justice Roberts noted in his opinion for the court, because usually when Congress wants documents from the president, Congress seeks those documents directly from the White House or directly from the president. And then usually this sets off a degree of negotiation, the hurly-burly of the political process, to use the phrase that the Chief Justice invoked, that there is some back and forth and ultimately, in the usual instance, some degree of accommodation. But that process couldn't occur here because Congress did not seek documents from the president directly. Instead, Congress sought documents from the third party, putting Trump in the position of having to file a motion to quash those subpoenas, and that's what set off the legal proceedings here. The other thing that I think is particularly important to remember about the congressional cases about Mazars is that Congress made no claim that these documents were pursuant to or part of any sort of impeachment inquiry. That claim of authority by Congress was off the table. Rather, Congress asserted from the beginning and throughout this litigation that it was demanding these documents as pursuant to its authority to engage in legislative oversight. And I think that made this case more difficult than perhaps it needed to be. And certainly, I think that figured into its ultimate resolution by the court. Congress's assertion of authority in this case was extremely broad. Congress essentially claimed that anything plausibly related to its enumerated powers could be the subject of legislative oversight. And in fact, in the course of the litigation and in oral argument, the attorney for the House of Representatives was repeatedly asked to identify information or documents that would be beyond Congress's ability to subpoena. And he came up empty. At one point, he suggested, well, maybe the president's medical records might be off limits, but then realized that because of the 25th Amendment, because Congress has the authority to operationalize the 25th Amendment, which relates to presidential incapacity, well, then certainly medical records might be relevant there. Further, Congress had asserted the authority to use its oversight power to demand documents for the purposes of conducting a case study of potential abuse or potential evasion of federal law, and that the president could just randomly be identified as a potential case study for such investigation. And that, I think, illustrates or evinces Congress's belief that any limits on its oversight authority would be political and would not be constitutional. I think it was clear at oral argument that when Congress could not identify limits on its authority, that this was going to be a problem. And so while the court in Chief Justice Roberts' opinion rejected the president's claims of immunity, 7-2, and rejected any argument that any sort of heightened need needed to be demonstrated apart from any claims of executive privilege, the court also rejected the assertions by Congress, rejected the tests put forward by the lower courts that essentially Congress could demand any such information that it wanted pursuant to its legislative oversight powers. The court noted that Congress's investigatory power is derivative of its legislative powers. And I think it's important to recognize, and certainly at the Cato Institute, it is generally recognized, that Congress's powers are limited. and that if Congress's legislative powers are limited, that its investigatory powers are limited as well. Now, one possible argument would be, well, the limited nature of Congress's enumerated powers is a sufficient limit on its investigatory powers. The court did not accept that, and I think it's easy to see why the court did not and could not accept that. First, this case study rationale that Congress put forward would allow Congress to select anyone for pretty much any sort of reason to investigate. But more importantly, because Congress has the power to propose amendments to the Constitution, that means if Congress's ability to investigate is as broad as Congress's ability to initiate or propose legislation, and that includes proposing amendments, then that investigatory power would in fact be infinite, would not be subject to any limits, and that would be a problem. So the court, in rejecting any sort of claim of presidential immunity, also, as I noted, rebuked Congress's claim that it essentially could investigate anything it wanted, and instead tried to identify 4 factors that lower courts should consider when evaluating subpoenas of this sort. And I think what the Chief Justice was trying to do was to identify the sorts of factors that usually come into play when Congress is in the position of negotiating with the executive branch for documents. And the Chief Justice said that these are the sorts of criteria that courts would have to consider in the future. And these criteria are, first, the court has to consider whether or not there's an actual legislative purpose that requires papers from the president, as opposed to, say, from other individuals, as opposed to individual agencies. It's important to note here that various federal agencies, various federal departments are creations of Congress. Congress created them, funds them, and so on. The presidency, on the other hand, is not created by Congress. It is a constitutionally created office, so Congress doesn't necessarily have the same degree of oversight. Also implicit in this factor is the court's rejection of Congress's claim that because the documents were sought from third parties, there could be no intrusion on the president, there could be no separation of powers concerns. The court did not accept that argument. We all recognize that Congress wants these documents because Donald Trump is the president, and that raises separation of powers concerns, even if the actual physical document request is being put to a third party. Second factor courts have to consider is whether the request is broader than necessary. Does Congress really need records about Barron Trump's credit card swipes or his checking account? Does Congress really need information going back as far as Congress asked, and so on? That Congress would have to, or a court should ask whether Congress is sweeping too broadly. Third, whether Congress offered evidence of a valid legislative purpose. It's not simply enough for Congress to just say, we want or need this information. And fourth, whether the request would in fact impose undue or unreasonable burdens. I think this factor is relatively easy to meet in this case. Mazars presumably has these documents. It should not be that difficult for them to produce them, but it's certainly plausible that a president would want to review those documents to see if there are any specific documents that any kind of claim of privilege could be invoked for. And that was something else that courts would have to consider. Now, as I noted before, this is all about Congress's legislative powers. This is not a case about what documents or information Congress could demand pursuant to its impeachment powers. And I think that's important because the court is basically saying, look, if you're investigating the president for a legislative purpose, we do want to know that you're actually investigating this for a legislative purpose. If Congress were investigating this for an impeachment purpose, that presumably would raise a different set of considerations, and presumably Congress's ability to investigate the president as the president would be much broader. Why didn't Congress invoke its impeachment power? Well, I think it's because Congress recognizes that putting impeachment on the table, invoking the I word, produces a degree of political pushback that legislative oversight does not. And I would argue that that's the way the system is supposed to work. I think that Gene Healy at Cato's work suggesting that Congress should be more willing to put impeachment on the table than it traditionally does is certainly a valid argument, certainly an argument I accept. But if Congress wants to investigate the president because he is the president, Congress should be willing to acknowledge that it is using its broader power, it is using the impeachment power. And then if Congress isn't willing to do that, it is reasonable for courts to make Congress show that it is in fact pursuing a legitimate legislative purpose. In these particular cases on remand, it is unclear whether or not these particular subpoenas will satisfy that. I think the House Intelligence Committee subpoena is the most closely connected to the House's legislative authority, whereas the Oversight Committee's subpoena, I think, is a little more speculative, but that's something that courts will have to consider on remand. I'm probably pretty much out of time, so I will stop there, and I look forward to our conversation and any questions that folks may have. Thank you.
Thank you, Jonathan. We can go right into Elin discussing Seila Law or Seila Law. I'm not sure which one it is yet. Elin?
Thanks so much. Well, I say Seila Law, so that's what I'm going to go with today. Well, thanks everyone for having me. As I said, the case I'm going to be talking about is Seila Law v. CFPB, the case in which the Supreme Court held that for-cause removal protections are unconstitutional for a single director agency, in that case, the Consumer Financial Protection Bureau. I'll start by briefly discussing how we got here. Why was this even an issue? So I'll talk about the precedents leading up to the case, and then I'll note some important implications and unanswered questions, namely, what's left of the theory of quasi-legislative power from Humphrey's executor, as I'll discuss, and then some of the questions over the meaning of the executive power, this grant to the president in Article 1 and Article 2, Section 1. So how did we get here? Let me start with that. Well, it all goes back to the decision of 1789, or the maybe decision of 1789, in which Congress debated whether the principal officers of the first three departments should be removable at the pleasure of the president, or rather by and with advice and consent of the Senate, the same way they're appointed. Remember, there's no removal clause in the Constitution, which seems to be silent on the question. Well, Congress decided that the officers were to be removable at the pleasure of the president. But it's a bit unclear whether a majority thought this was constitutionally mandated by the executive vesting clause, or maybe the take care clause, or whether some thought that it was up to Congress's discretion whether to assign the removal power to the president, or whether Congress could retain a role for itself, or the Senate could retain a role for itself. So that was the maybe decision of 1789. Well, fast forward to a case called Myers v. United States in 1926. Former President Taft, then Chief Justice of the United States, held in this case that all officers appointed by and with the advice and consent of the Senate had to be removable by the president. The Senate, in other words, could not retain a role for itself. This applied even to inferior officers appointed by the default advice and consent method. Congress could, of course, vest the appointment of such inferior officers in the principal officers, right, and could limit the ability of the principal officer to remove the inferior officer. But until Congress does so, the president's discretion, removal discretion, is unhampered, so said Chief Justice Taft. By the way, an aside, note that Taft never actually said that if Congress does vest the appointment of an inferior officer and a principal officer, Taft never said that that means the president couldn't remove the officer at the president's discretion, right? The prior cases had only said the principal officer could be restricted in the ability to remove, but let's put that aside. Okay, then we get to 1935, and here is where the key precedent is. This is the Humphreys executor decision. This was a functionalist decision upholding for-cause removal provisions for FTC commissioners. The court reasoned that the FTC wasn't exercising executive power, nor was it exercising legislative power, nor judicial power. Instead, it was exercising quasi-legislative, quasi-judicial power. The reach of Myers, the court said in Humphreys, extends only to officers exercising purely executive power. Well, what exactly is quasi-legislative power? As the Supreme Court explained recently, I think in 2013, in City of Arlington, executive power sometimes takes legislative or adjudicatory forms, right? Like a regulation or an administrative adjudication, but that doesn't make it legislative or judicial power. It's still executive power. And as I've argued in numerous of my own writings, I believe there is such a thing as non-exclusive power, meaning power that can be exercised by more than one branch. For example, many regulations can be done by the executive or by Congress, right? So it's not exclusive. But the concept of quasi-legislative power is this idea that there's a category of power that needs to be exercised neither by Congress, nor the executive, nor the courts, but rather can be exercised by some other officer not controllable by any of the constitutional actors named in the Constitution. So this is a new category of power altogether. And there's no room for that power in the Constitution. At least the Constitution, does not seem to contemplate that power at all. So in my view, Humphrey's executor seems clearly wrong on its reasoning. Now, there could be a way, this is important, there could be a way to support the result in Humphrey's executor. If the executive power clause, right, the executive power shall be vested in a president of the United States. If the executive power clause is not a grant of power, and therefore the only power the president has to execute law is that which is necessary to take care that the laws be faithfully executed, then I suppose it's a functionalist question. It's a functionalist analysis, whether removal restrictions are or not consistent with this take care duty. After all, surely the president could remove for faithless execution, even if there's a for-cause removal provision, right? Saying only remove for inefficiency, neglect of duty, and so on. But the president wouldn't be able to remove an officer for mere policy disagreements, right? So long as the agency is acting within the bounds of the statute. If the agency is acting within the bounds of the statute, then it's still faithful execution, even if the president would have done it differently. Okay, well, I promise I'm almost getting to Seila Law. Fast forward again to 1988, and the Supreme Court in Morrison v. Olson upheld the independent counsel statute. The independent counsel was exercising executive power. The court admitted that, but it was nevertheless okay to insulate the independent counsel from removal because doing so did not impermissibly interfere, that's the court's language, impermissibly interfere with the president's ability to execute the laws. So we have a different kind of functionalism in Morrison v. Olson. Quasi-powers are out, or at least they don't always matter. And the president's control over even executive officers can be limited. Well, that was the functionalist era between 1930 and I guess the mid-2000s or so. Then the court, the Roberts Court, the early Roberts Court, I guess, started a return to formalism with a case called Free Enterprise Fund in 2010, where the court said that 2 layers of for-cause removal protections is too much. In other words, in Humphrey's executor, remember, Congress could insulate principal officers, the FTC commissioners, from removal by the president. They could protect the commissioners by for-cause removal provisions. And earlier cases, in a case called Perkins principally, but some other cases, the court had said Congress can also insulate an inferior officer from at-will removal by the principal officer. What the court in Free Enterprise Fund says is you can't combine them, right? If an inferior officer is protected by for-cause removal protections against the principal and the principal is protected by for-cause against the president, that's a new situation. You can't combine the two because that interferes too much with the president's executive power. So Free Enterprise Fund reflected the approach of the Roberts courts to not overturn prior functionalist precedents, but also to extend them to new situations. Well, is the CFPB a new situation? The difference is that it was a single director independent agency, that is a single principal officer protected by for-cause removal protections. Now, some of you might be saying, well, wasn't the independent counsel principal officer? Well, maybe, but the court said she was inferior, so put that aside. So the CFPB still represented something new. So what did the court do? It kind of did the Free Enterprise Fund approach. It said this is a new situation. The rule of Humphrey's executor allowing for-cause removal provisions only applies, the court said, to multi-member bipartisan boards that can check and balance each other. Of course, The dissent correctly noted that Humphrey's executor had actually little to do with that. It had to do with the nature of the power being exercised. But that doesn't give me heartburn. After all, Humphreys can be supported on the original meaning, if at all, if the president's only power is what can be implied from the take care clause. And again, that's a functionalist analysis. So what's wrong with a functionalist rule? It says it's not too much interference with the president's duty if you have a multi-member bipartisan commission that can be neutral and expert. A single director of a single political party will be neither neutral or expert. Okay, so to wrap up, what does the future hold? What does the future hold? Will the Supreme Court keep the old precedents, but refuse to extend them to new factual circumstances? Well, it's not clear. It now appears that all 9 justices on the Supreme Court agree that there's no such thing as quasi-legislative power. Thomas and Gorsuch said it explicitly in their Seila Law concurrence. The court earlier in City of Arlington had said it, and all the dissenters in Seila Law in a footnote agreed that it's all executive power. So nothing is left of Humphrey's reasoning. As for Morrison v. Olson, that was cited not for the functionalist test, but for the formalist proposition that principal officers can be restricted in their ability to remove the inferior officers. So in a future case, will the Supreme Court overturn Humphrey's executor? Certainly, I think it will be open to such a challenge. And the question then is, should the court overturn Humphreys? What should the court do with Humphreys? And the short answer, and I'll end on this, is it depends on the court's view of executive power. As I noted, Humphrey's executor can be supported on originalist grounds if the president's only law execution power is what can be implied from the duty to take care of. Then it's just a functionalist analysis. But if the executive power is a grant of power, at a minimum a grant of law execution power, then it seems that law execution belongs to the president, whether the officer is principal or inferior. And then Humphreys, I think, has to be overturned. So what is the meaning of the executive power? I'll just flag that in a recent paper for the Duke Law Journal called In Search of Prerogative, and I summarized this briefly in my paper for Cato in this conference, I argue that the executive power is a substantive grant of power. Now, that's not particularly novel. Foremost have been saying it's a grant of power all along, a residual grant of all executive powers not assigned elsewhere in the Constitution. Well, in my paper, I argued that the executive power was a grant of power, but it wasn't a residual grant. It was only a grant of law execution power. But even under this narrower grant, the president has the authority to remove officers who assist in executing the law. Any law execution discretion is the president's to exercise. A residual reading of the clause just isn't necessary for the argument, and it also happens to be historically wrong. But for that argument, I'll leave it up to you whether you want to read that other paper, and I'll leave things there. Thanks very much.
Thank you, Elon. Just so everyone knows, we are taking questions. We will be doing those after, so you can do this on Twitter, hashtag Cato SCOTUS, Facebook, and you can also write them into the Q&A. Now I will turn it over to Peter Margulies to discuss the DACA cases. Peter?
Thanks, Trevor. I'm going to go ahead and share my screen, so I hope this has been enabled for participants. And what I'm going to do is start out with a discussion of what constituted the DACA program. And DACA was a program of the Obama administration that reacted to the inability of Congress, or the unwillingness of Congress, to help the so-called dreamers, that is, folks who came to this country as kids from other countries, basically knew no other home but the United States. After Congress passed or failed to pass the DREAM Act, Obama acted in 2012 through his Secretary of Homeland Security, Janet Napolitano. DACA gave benefits to people who arrived here as kids, and DACA stands for Deferred Action for Childhood Arrivals. And those benefits came in 2 buckets. One was you got a reprieve from removal. You wouldn't have to leave this country. And 2, you got work authorization. Both very important benefits. Now, that's a bit of a tension, as Justice Thomas mentioned in his dissent in the Regents case, a bit of a tension with the structure of the Immigration and Nationality Act, the INA, because the INA generally specifies narrow classes of people who can receive visas as immigrants. And basically those visas involve family ties to U.S. citizens or lawful residents, or various kinds of skilled employment. That's pretty much about it. Other foreign nationals who are here who don't have that kind of status based on family or employment are largely subject to removal, to deportation, unless they get what we call temporary deferred action. But that's also very rarely granted. It's granted as kind of a bridge to lawful status for people, let's say, who've applied for a family-based visa or an employment-based visa and are waiting to get it, having filed a good faith substantive application. And it's also given just to a small group of people with real hardships, the people of extreme age, for example. So I had a client who was 80 and suffering from Alzheimer's, and DHS said, we're not going to force you to go back to your country of origin. That would be inhumane. So that's the limited hardship grant that's also part of deferred action. But DACA went well beyond that. It was a pretty big program, 700,000 people. So that's the tension with the Immigration Nationality Act scheme that Justice Thomas mentioned. DACA actually, although it was big, was not anywhere near as big as the biggest President Obama initiative, which is deferred action for parents of Americans. That's the DAPA program, which would given deferred action, reprieve from removal, employment authorization to the parents of birthright citizens, people who came here without a status. That program was enjoined by the courts, never got off the ground. President Trump then, when he arrived in office, decided fairly early on, in part through colloquy with Texas and other states that opposed DACA, that he would rescind DACA as well. And acting Department of Homeland Security Secretary Elaine Duke, in fact, did that in September of 2017, based in part on a letter from Attorney General Sessions that said DACA was illegal, just like DAPA was. This program was enjoined by the courts during the Obama administration. But there was little reasoning supporting Sessions' conclusion or Duke's memo, and that came to haunt the administration. In DHA's versus Regents of University of California, where ironically Janet Napolitano had started the program as DHS Secretary under Obama, was now chancellor, the court, in opinion by Chief Justice Roberts, found that DACA recipients had reliance interests. In other words, they had programs like being in school, receiving medical treatment, being in the armed forces, that they had bought into, that required some time to run their course. And so they would be damaged, they'd be harmed if these programs were cut short. And indeed, Chief Justice Roberts said that U.S. citizens and various U.S. entities like schools, employers, and the U.S. military would have called negative externalities, that is, harms that they suffer, not the parties to a case, if they had to end ties with DACA recipients, when they put in money and resources, time and effort into educating people, providing medical care, training people in the armed forces, etc. So those reliance interests and negative externalities for Roberts triggered under the Administrative Procedure Act, the APA, a requirement that the administration engage in what Roberts called reasoned decision-making, time-honored doctrine of administrative law, before it could rescind the program. And for example, Roberts said you could have considered separating out the reprieve from removal and the work authorization pieces of DACA, maybe ending the work authorization, because that posed the greatest tension with the Immigration Act statutory scheme, but continuing with the reprieve from removal, which is more of a garden variety exercise of prosecutorial discretion. The rationale is more fully explored in my article for the Cato Supreme Court Review, which is now on SSRN and shortly in print in the Review. And to me, this is really, although it's a statutory case based on the Administrative Procedure Act, in many ways it does hark back to the framers. It involves a duty to deliberate. It doesn't involve a duty to reach a particular outcome, and that's quite important because Roberts said if the deliberation had been adequate, had been comprehensive, had been diligent, then the agency could have done what it wanted. It could have rescinded DACA, but it's the deliberation that was lacking. Of course, that's very much like the kind of process that the framers talked about. For example, Hamilton, Federalist 78, of course, talked about judgment as the virtue of the courts and the need to have a more far-sighted approach as opposed to being hung up on short-sighted humors, as he called it, of the political process. And here, though, the agency did not deliberate, and Roberts says that deliberation was the agency's job and its responsibility. That was the kind of deliberation the framers would have expected. That was not the deliberation that DHS exercised here. Thanks.
Thank you very much, Peter. We have said we're opening it up for questions. You can ask that in the Zoom here. You can also ask it on Twitter, which I will be trying to keep an eye on, but also my associate Sam Spiegelman will be keeping an eye on, and also on the Facebook feed. I'd like to start with first to ask if any of the panelists have any commentary on the other cases that you can cover on this panel. If anyone has anything to say on that.
Can you hear me?
Yes.
I have actually some questions for both Peter and Jonathan. I'll start with Peter since I guess it's more legal. On the DACA decision, I was sort of puzzled by this. If DACA was acknowledged to be a discretionary program, so the executive, there's no question. So at best discretionary, and at worst it's illegal, which I think was the Trump administration's view. I understand. I mean, I teach administrative law. I get to State Farm on Monday, and I understand under State Farm and Fox Television and arbitrary and capricious review, generally the administration has to consider reliance interests of a previous rule before rescinding that rule. But why should it be the case that the agency or the executive ever has to consider reliance interests of an unlawful program? If it believes it's unlawful, why, is it just a matter of showing its work and saying, we get those reliance interests, but we don't care because it's unlawful, and so we're gonna overturn it? Like, why wouldn't that have been? And why wouldn't that have been enough? And I mean, I think that's what their view was. And then, well, I guess
Similar to the
question. I'll stop there.
It's similar to the question here in the chat from David Frost. Once the agency concludes that the original administrative action was unlawful, why should deliberation be required? That's a similar question.
That's a great question, and it was a question asked in a very acute way by Justice Thomas in his dissent. And frankly, I think this is a close case, particularly because of that very issue. But having said that, I do ultimately think that Chief Justice Roberts got it right when he said that there's not a lot of precedent for setting up a program that helped this many people and that triggered the kind of reliance interests that were at stake here, people being in school. So for example, just a very quick anecdote, if you were starting in school in 2016-17, and you'd be a sophomore in 2018 and your DACA status expired on, let's say, March 6th, 2018, you'd have to leave school right in the middle. And Roberts said, that's just not right, at least not without some consideration of the cost to that person and to that person's home institution. And so one way of looking at it is that it's really about American interests, both entities like schools and the teachers in the schools, officers in the armed forces, everyone else who established reliance interests and ties to these folks. And community ties have always been important in immigration. You could also argue that this is really a question of remedy, that even if you believe DACA was illegal, the administration still has discretion in how to wind it down. Right? A court, if it finds a practice to be illegal, doesn't have to stop it immediately. In entering an injunction, the court has discretion to tailor that injunction to the various equities of the case, including reliance interests. And so I think one thing that Chief Justice Roberts is really saying, and quite put it this way, is that DHS could have exercised greater remedial discretion or could have explained why it chose not to do so. Right? Secretary Yu did not do that in September 17. Arguably, Then Acting Secretary Nielsen did more of that in June 2018. But because of another administrative law doctrine, the Chenery Doctrine, Roberts basically sliced off Nielsen's rationale, said the court can't consider this. That's impermissible post hoc rationalization. The agency only gets one bite at the apple. That's Duke's explanation in September 2017. And that, again, was a very stark, conclusory explanation.
Jonathan, did you have something you wanted to add? You're up. Nope. The question.
If I could, sorry, I was having trouble unmuting myself. Yeah, I have a similar question, but I would put it a little bit more pointed, or I'll raise my concern in a more pointed way, which is the majority goes out of its way to never say whether DACA was legal or illegal. So the underlying lawfulness of DACA is not relevant to its determination. I think an inescapable conclusion of that is that under Chief Justice Roberts' opinion, an agency could have the obligation to continue violating the law, to continue exercising powers that it does not have or that it is not exercising lawfully, unless and until that agency is willing to engage in some sort of broader discussion of purported reliance interests. And I think that's, even though I actually think that DACA was quite possibly legal in the first instance, and Peter and I may disagree on that. If it is illegal, I think it's hugely problematic that doctrine says you must continue to engage in illegal conduct. And if you think about this going forward, if, let's say Joe Biden wins the presidential election this year, there are all sorts of actions the Trump administration is taking in the regulatory context that are potentially unlawful. It's waters of the United States definition. While people are getting jurisdictional determinations that are supposed to last for 5 years under that rule, the Biden administration would not be able to simply rescind those on the basis that they were unlawful. Permit applications for various projects, the new NEPA regulations that just went into effect this year. There's a whole wide range of things that under Chief Justice Roberts' opinion would have to be allowed and continue to be allowed even if they are unlawful. And I think that's, as someone who likes DACA as a policy matter, who thinks it was lawful, I'm nonetheless very troubled by that potential implication of the Chief Justice's opinion.
Just a quick response. Secretary Nielsen's explanation for the rescission of DACA in June 2018 didn't really involve a lot of heavy lifting. That was a 2.25-page memorandum that a skilled lawyer could have written in basically a couple of hours. Right? That was all that was required here. So it's not a lot. And Chief Justice Roberts was at pains to say, you don't have to continue the program. You just need an adequate rationale for rescinding it. So if DHS had done in September 2017 what Nielsen did in June 2018, probably given the general tenor of Roberts' analysis, they would have been fine. And so that raises the question, why didn't they do that? That should have been sort of due care. The Constitution Article 2 does talk about the obligation to take care that the laws are faithfully executed. And Roberts says that's in fact a responsibility of government. It's not unreasonable to impose a responsibility to come up with a 2.25-page memorandum.
I have a question for Elon. A good friend of mine, a former Cato Director of Financial Regulation, Mark Calabria, is now the Federal Housing Finance Administration Director. Is he not long for this world in that position?
I may be conflicted out of answering this question actually publicly, because, and I actually am serious about that, and I'll have to think about that for a second. So I guess what I will say is, if the FHFA is exercising executive power, then he's not long for this world. Maybe there's an argument it isn't, and I'm not sure the strength of that argument. Just supervising Fannie Mae and Freddie Mac. I mean, there are other problems. They do initiate civil actions and enforcement actions against private parties and banks. So I don't know. So He may or may not be long for this world. I certainly would be looking for a backup job, just in case. That never hurts. Can I know we're running out of time.
Oh, we have 15 minutes, so you're please.
Because this is an administrative law panel, basically. I do have one other question then for Peter. You seem to recognize that Secretary Nielsen's June 2018 memo was much more detailed, and in fact, it did consider reliance interests. The Chenery 1 decision that you alluded to indeed says, an administrative decision has to be judged on the basis of the reasoning and the time, right, and what's before it. But why wasn't the decision under review Secretary Nielsen's decision? Why wasn't that the rule under review? After all, the APA defines a rule as any statement of general or particular applicability and future effect designed to implement or prescribe law or policy. Why wasn't Nielsen's statement in June 2018 the rule under review instead of the earlier one from 2017 that was cursory? Now, I understand Secretary Nielsen said, I declined to disturb the earlier decision, and then for all these reasons. But are you saying if she had said, I rescind the decision and I now reimpose a rule, create a new rule, that new rule is identical to the rule she rescinded, would that then have been the rule under review? I mean, is that even I'm pretty formalist, and even I wouldn't go by that distinction, right? So why wasn't hers the ruling under review? A much more recent decision of hers.
Elon, that's also a wonderful question. So Justice Kavanaugh addressed that in his dissent. And he argued that Chenery is actually a narrower doctrine than Chief Justice Roberts outlined, that it is basically designed to guard against agency lawyers concocting a rationale in the middle of litigation just to come up with something that's going to satisfy the courts. And he said Nielsen was not an agency lawyer. She's a principal in the agency. She's the acting secretary, for God's sake. And so what she says really isn't covered by Chenery at all. That too, like Thomas's dissent on the substance of DACA, is in many ways a powerful kind of argument. And again, what helps make this a very close case in my view. But I would say, nevertheless, that the agency had an opportunity to do exactly what it did with Nielsen much earlier with Duke in September of 2017. It just would have involved a bit more nuance. Again, 2.25 pages worth. Instead of being just consenting to what A.G. Sessions had said, Jeff Sessions had said, which is that DACA is not merely illegal, but is unconstitutional. And that's far less clear. That wasn't raised in any of the litigation on DAPA. And so it's not even clear where Sessions got that argument, that DACA is unconstitutional. That to me was just not really diligent or well-informed lawyering on Attorney General Sessions' part. And Duke then, I think, fell victim to the same problem when she had her, one-paragraph conclusory view of DACA's legality. So again, it wouldn't have required a lot to satisfy Roberts on that point either. And so that leaves me at least scratching my head saying, why was this administration so unwilling to at least take a couple of hours to deliberate about this when the stakes were so high for both the DACA recipients themselves and all the folks who they interacted with, both entities and U.S. persons?
Question here from Pat and Jim. Don't courts recognize reliance only if it's reasonable reliance? And if so, wasn't reliance unreasonable in the DACA case because its constitutionality was challenged from day one and the companion DAPA program was enjoined by the courts?
Well, that's a fair question as well. And I guess the best answer is that DHS could have said from Jump Street, as Nielsen said in June of 2018, that there may be a reliance interest here, but they are not reasonable, right? And Roberts apparently would have been okay with that. But the difficulty with Duke's memo in September 2017 is that it says virtually nothing. And it also left people high and dry. That college person I mentioned who have to leave school on March 6th 2018, because the DACA wouldn't have been renewed at that point. It left him high and dry without explaining that this was necessary for enforcement of the law, that it was best to have Congress make these kinds of decisions about who get this precious good of work permits, right? Again, it wouldn't have been tough to do that in September of 2017. Why all the hurry, right? And so that, I think, is really, again, a value that the framers emphasized. Hamilton was all about being careful. That's why he praised judicial review. And Marshall and Marbury versus Madison had very much the same thought, that we need that second look from the courts, because otherwise the political branches will act precipitously. Precipitous action, unfortunately, across the board has been what this administration has been about. Another example is the census case, saying that we're going to ask the citizenship question. Of course, I think those two cases where Roberts said in the Department of Commerce case in 2019 that the census argument made by the Department of Commerce was pretextual. The Department of Commerce said this about the Voting Rights Act. Roberts said that just doesn't hang together as a rationale. And so part of the problem for both the census case and the DACA case is the administration was not able to come up with anything like a cohesive rationale for what it's doing. And I do think that's a minimum requirement of rationality. Otherwise, you could say, maybe the administration could have said, we just feel like rescinding it, right? And maybe that would have been okay too. But it's coming up with a substantive reason like this is unlawful without backing it up. That's the problem, because what that suggests is that you want to have your cake and eat it too. You don't want to say, we just feel like doing it. You want to cloak it in some rationale, but then you don't want to fully explain that rationale or deal with the consequences.
Does anyone have any thoughts on the question coming up here? Here's one from Francis Brickfield for Elon. In the CFPB case, what role did the funding mechanism play in the decision? That's an interesting question.
It's one of those classic judicial maneuvers where they say, well, for this additional reason, we are particularly concerned, but we're not sure, it's not clear that the decision would come out the other way, or that this is actually central to the decision. So it was a throwaway line where the Chief Justice says, and in this case, we are particularly concerned that the funding, it's basically self-funding through fees and things like that. So there's no congressional oversight either through the appropriations process. And then there was one other thing that concerning about this particular structure, but they were throwaway lines, and I wouldn't, bank on that being the distinction between FHFA and the CFPB, because it really wasn't ultimately determinative of the outcome. It makes it all the worse, right? The structure of the CFPB, it makes it all the more insulated, but it really wasn't determinative of the outcome, I don't think. They did say that. Yeah.
Does anyone have any thoughts on the one of the unifying things about all the cases discussed on this panel is that all were decided by Chief Justice Roberts. Now, it might be for different reasons. And also the census case, as Peter brought up, which does seem like it's a kissing cousin to the DACA case. Is there a significance to Roberts writing these opinions?
I would say there is. I mean, I think Roberts is at heart an institutionalist. He cares deeply about the court's legitimacy and credibility. And I think he came to feel, starting with the census case and then going on to DACA this term, that this administration really didn't care that much about the legitimacy of American institutions of governance. And so I think Roberts was really pushing back.
I would say that these cases certainly reflect Chief Justice Roberts' general approach to questions. It's not simply, I think, pushing back against administrative irregularity. I think he cares about separation of powers. I think he cares about those questions. I think he also, has what I've characterized as a conservative minimalism that is observable in all of these cases. That is to say, he wants to reaffirm his fairly formalist understanding of separation of powers, but wants the ultimate judgments that the court issues to be fairly non-disruptive and status quo oriented. So in the CFPB case, he reaffirms the underlying formalist principles, but is unwilling to carry those principles to their logical conclusion and overturn prior precedents, and through severability, issues a judgment that really doesn't change much on the ground. In the DACA case, he wants an outcome that is very status quo oriented, respecting the reliance interests, even at the possible expense of the underlying separation of powers principles he cares about. And I think in both Vance and Mazars, those cases in many respects reaffirmed his understanding of what the status quo was or should have been. The longstanding principle that the president is not a monarch, is not fundamentally immune, certainly not for things that were done outside of office. And I think the Mazars decision really was trying to replicate in a court judgment the sort of outcome that you see when Congress proceeds directly to the White House or directly against the executive in seeking documents rather than going through court. And I think those all reflect this kind of status quo, anti-disruption impulse that the Chief Justice has exhibited.
My friend Joseph Bishop Hinchman has a question for Elon, that the good libertarian is uncomfortable with the administrative state precisely because it's a hybrid fourth branch. Congress and the president have together decided to delegate their power to such entities imbued with expertise. Humphrey's executors seem to acknowledge this political compromise, but should these agencies be recast as purely executive agencies, and is that what the CFPB case does?
So, I mean, there are a couple of things we can say about this. So, actually, the question took a different turn at the end. I thought, or maybe this is what you're getting at, that maybe Humphrey's executor is a good sort of second best situation where if we're going to be, I guess this is your question, if they're delegating all this power to the executive, do we actually want an accumulation of power in the executive? Ilya Somin, not Ilya Shapiro, for this reason argues that he's a George Mason, argues that Humphrey's executor or these independent, agencies are actually sort of this constitutional second best mechanism. So it's sort of a theory of the constitutional second best. If delegation of power is inevitable, delegation of legislative power to executive agencies is inevitable, and that's unconstitutional, well, we may as well do a sort of a second unconstitutional move to rejigger things a bit, to rebalance things a bit. There's a famous article arguing for a legislative veto on this reason. Yes, the legislative veto is unconstitutional, but so is this delegation of legislative power. Let's just stop pretending it's not legislative power. Let's call it legislative power, but give Congress a back-end veto. And wouldn't that be better for checking and balancing? And the short answer, I think, is yes. That certainly is plausible. But again, to be clear, the world isn't going to fall apart. It's not like by getting rid of these for-cause removal provisions, the president all of a sudden is going to have so much more power than she or she previously had. I mean, there's a huge political cost, right, to removing an agency head. And then the agencies themselves, to the extent they're still independent commissions, still have, the bipartisan composition. So if the president removes them, the president would still have to appoint someone so that there's still that majority plus one of one political party, unless the appointment mechanism, unless that's unconstitutional for some reason. But I'm not convinced that it's unconstitutional for Congress to set conditions of appointment. So the president's power would still be limited. I mean, it's not a huge transfer of power to the president if removal restrictions were struck down, but it would give one more political check against abusive agencies, and I think that would be a good thing.
One of the questions that struck me during the run up to the Seila Law case was, I wonder, in Elizabeth Warren, when she was still in the running for the possible Democratic presidential nomination. So I wonder what she thought about that, because she wanted to set it up as an independent agency. But if she won the presidency, she would want to fire the person immediately who was running it so she could make it, So, did she weigh in on the structure of this, but then suddenly had a personal interest in being able to fire the guy? And I didn't ever see anyone weigh in on that, but it struck me as an interesting concern. That
is interesting and reminds me of the other factor that they mentioned, other than the appropriations being self-sufficient. They also said because the term was 5 years, that means a president might never get to appoint a director of his or her choice, and that added to the problem. But again, that's sort of overdetermined. But I would love to see what Senator Warren has said about that.
Well, we are right here at the time, and this is the time where I would usually say, join me in thanking our panel to our audience. So you can clap it in your home for everyone who participated. Thank you, Peter and Jonathan and Elon. We will have an hour break for lunch, and then we'll be back here at 1 for the panel on criminal law and accountability. So thank you, everybody.
Thank you.
You.
read about this or hear this? That you used to go up on Mulholland Drive and park
every night
and visualize seeing yourself as.
Yeah, I would visualize.
This is when you were broke and poor.
You know, right, having directors interested in me and people that I respected saying, you know, I like your work or whatever that is, and I would visualize things coming to me that I wanted or whatever. Drive home and think, well, I do have these things. They're out there. I just don't have a hold of them yet, but they're out there. I wrote myself a check for $10 million for acting services rendered, and I gave myself 5 years, or 3 years maybe, and I dated it Thanksgiving 1995. Just before Thanksgiving 1995, I found out that I was going to make $10 million.
Good afternoon. Welcome back to Cato's 19th Annual Constitution Day. This is panel 2, Criminal Law and Accountability. I'm Clark Neely. I'm Cato's Vice President for Criminal Justice. Before we get started, I'd like to remind everyone that you can, and we encourage you to submit questions online. You can do that through Zoom, Facebook, Twitter, and YouTube. On Twitter, we are at #CatoSCOTUS. And I'll remind you a couple of times throughout the program. We will save time at the end of the event for your questions, and we look forward to answering them. Today, we have 3 wonderful panelists to discuss our topic, which is criminal law and accountability. First, we have Paul Larkin, who is the John, Barbara, and Victoria Rumpole Senior Legal Research Fellow in the Meese Center for Legal and Judicial Studies, where he works on criminal justice policy, drug policy, and regulatory policy. If I went through all of Paul's relevant CV, we would not have time to talk about anything else, so I will simply highlight that he was an assistant to the Solicitor General, where he argued 27 cases in the US Supreme Court, and also served as counsel to the Senate Judiciary Committee. Next, we have my colleague, Jay Schweikert, who is a policy analyst in the Project of Criminal Justice. Jay is standing in for one of our guests who was unable to make it today. We were going to have Professor Stephen Vladeck from the University of Texas, which is my alma mater, here to talk about the article that he wrote on the Supreme Court case Hernandez v. Mesa. But unfortunately, as I said, Steve is unable to join us, but Jay will handle that stand-in ably because it touches on an issue that is near and dear to Jay's heart, and much of the work that he does at Cato is relevant. And last but not least, we have Dr. Nicholas Mosvik, who is a senior fellow at the National Constitution Center, a former Institute for Justice and Cato alum, as am I. He is a UVA law grad, and he has his doctorate in American history from the University of Mississippi. We're going to be talking about 3 different Supreme Court cases today. We're going to start off with Paul Larkin talking about Kaler versus Kansas, which presents the question of whether the US Constitution requires states to provide certain kinds of insanity defenses, and particularly the kind of insanity defense that enables someone to escape criminal liability when they know what they did, but they claim that they didn't know what they did was wrong. Jay will be talking about a case called Hernandez v. Mesa, which involved a cross-border shooting, a fatal cross-border shooting by an agent of the federal government who killed a 15-year-old Mexican national by shooting across international border, which raises all kinds of accountability questions. And then Dr. Mosvik will be talking about a case that I'm sure is familiar to everybody, Ramos versus Louisiana, in which the US Supreme Court finally got to the question of whether the 6th Amendment requires jury unanimity. Paul, would you kick us off, please?
Thank you, Clark. And thank you to everyone who's tuned in. And thank you to Cato. I'm honored that they invited me to speak today. The relationship between murder and madness has captivated novelists and filmmakers for decades. But the same relationship has also been the interest of criminal justice scholars and criminologists for centuries. The criminal law has drawn a distinction between offenders who are bad and those who are mad for hundreds of years. It has adopted numerous tests to try to address this sort of problem. There is the wild animal test, the total loss of understanding test, the famous McNaughton test, the product of mental illness test, irresistible impulse, and the American Law Institute test, which is really just a modern update of the old McNaughton test. Each one of them tries to separate people who are incapable because of a mental disease or defect of either knowing what they're doing or knowing what they're doing is illegal or immoral. The criminal law has always thought this is an important distinction because a parallel development occurring in the field of scienter during this period has been the limitation of liability from a strict basis to people who have acted in a way that they should have known was illegal or immoral. Kansas took a slightly different approach than most states in this regard. Kansas allows a defendant to show that due to a mental illness, he lacked the scienter element necessary to commit a crime. In the case of murder, that's premeditation and deliberation on an intent to kill. Or a person can use a mental illness to show that he should be confined not in a penal institution, but in a mental institution. What Kansas does not allow is a defendant to show that a mental illness robbed him of the ability to show that what he did was immoral. In other words, the mental illness so clouded his judgment that he didn't know he was violating the moral code. The facts of Kaler versus Kansas are pretty stark in this regard. Kaler was going through a terrible personal relationship with his wife, and they had been separated and were in the process of being divorced. His daughters had decided, he thought, to side with the wife in this regard, while his son, he thought, was on his side in this regard. His soon-to-be ex-wife, his estranged wife, and his children were spending the Thanksgiving weekend at his wife's grandmother's home. Taking an AR-15, a rifle used by the U.S. military, he went into the house, passed by his son, who, as I said, he probably thought was on his side in this dispute, and murdered his wife, his two daughters, and his wife's grandmother. The result was he had virtually no defense on the merits of the charge. He never denied that he had done the shooting. And given the circumstances, which showed that he intentionally, methodically, and systematically walked throughout the house to find his victims, he had no defense that what he did was intentional and premeditated. His only defense was insanity, but the way that he raised an insanity defense was a doozy. Rather than actually using the Kansas law, because he was not able to show that he couldn't know that what he did was immoral, he challenged its constitutionality. The problem for him is this: perhaps the most fundamental moral proposition that has existed from the dawn of Western civilization, and probably Eastern, Northern, Southern as well, is that the intentional premeditated killing of an innocent party is immoral. In essence, what Kaler was asking the Kansas courts, and then later the Supreme Court, to do was say that Kansas was constitutionally prohibited from assuming irrebuttably that anyone who intentionally murders an innocent person knows that what he or she is doing is immoral. When the case got to the Supreme Court, he relied heavily on the history of how the law treated the insanity defense, saying that historically the criminal law had always exculpated someone who, due to a mental disease or defect, didn't know that what he or she was doing was immoral. And the principle was so deeply embedded in Anglo-American law that it had to be adopted as a constitutional rule. By a 6-3 vote, the Supreme Court rejected that argument in an opinion by Justice Kagan. She started out by saying that he was wrong in claiming that his mental illness was of no use to him in defending against the charges. She said that what Kansas allowed was a defendant to show that mental illness robbed him of the scienter necessary for the crime, or that he should be confined in a mental institution rather than in a penal institution, or in this case, subject to capital punishment. The fact that he could make those defenses was all that the Due Process Clause required, as unable as he might have been given the facts to be successful on them. But Justice Kagan went on further. She deeply analyzed the history of Anglo-American treatment of insanity and rejected the argument that regardless of what a state does, the Constitution gives a defendant the right to show that because of mental disease or defect, he was incapable of understanding the immorality of his own conduct. As the result, she rejected his argument, and the decision in Kaler versus Kansas is one of a series of cases in which the Supreme Court has said the Constitution does not adopt, like the speed of light, a rule of insanity that applies everywhere, anytime, and for all time. Now, the significance of the Kaler case is, in part, what the Supreme Court did not do. Kaler was one of a small number of cases in which the Supreme Court, over the course of the last 70 years, has addressed the question of whether the Constitution adopts an insanity defense, and if it does, requires that states and the federal government use a particular standard to separate bad defendants from mad ones. In earlier cases, the question had been whether there is an irresistible impulse defense or whether alcoholism is a defense. Those were in Leland versus Oregon and Powell versus Texas, respectively. And then, of course, in Clark versus Arizona, you had essentially the mirror image of this, which is a defendant who claimed that he was entitled to show that he couldn't keep himself from knowing that what he was doing is what he actually wound up doing, even though he knew it was immoral. In each case, the Supreme Court has said that there is no one test that has been so accepted by Anglo-American legal history that it becomes the exclusive or at least a compulsory test for the federal and state governments to use. What is also potentially significant, however, is the methodology the court used in coming to this conclusion. The court relied almost exclusively on how history had treated this particular type of claim. History was more than just a factor to consider, and it did more than wear just a maillot jaune in this case. It was virtually the entirety of her analysis. Well, that is significant in potentially two other areas for the criminal law. One is strict liability, and one is vicarious liability. The common law started out with a strict liability basis, but then greatly became overcome by the distinction between people who know what they're doing is a crime and people who are engaged in activity that might be negligent. And for the longest period of time, only those who knowingly engage in conduct that is a crime or that is dangerous or that is harmful could be held criminally liable. During the mid of the 19th century, however, we started seeing states adopt a form of strict liability again, simply in the context originally of various types of business-related or health and safety-related crime. But it has gradually expanded to the point where it can be used by states and the federal government in a variety of circumstances where there is even imprisonment or worse, potentially, as the penalty. Plus, in cases involving prosecutions under the Food, Drug, and Cosmetic Act, the Supreme Court has upheld the use of vicarious liability by holding a president potentially liable for criminal prosecution in a case where he had no knowledge whatsoever of what was happening at a particular plant. The bottom line is this: the Supreme Court has upheld the constitutionality of strict and vicarious liability, but it is a very ahistorical type of decision. In a handful of cases decided since the early 1920s, the Supreme Court has allowed Congress and the states to use this theory. But if Kaler indicates that the dispositive criteria in deciding whether this is constitutional is the history of this use, then I think we'll likely see that people use that history to try to challenge these prosecutions in the future. The bottom line is this: Kaler probably and for all times closes the door to the potential claim that there is a constitutional basis for an insanity defense. It is really now something subject to legislative judgment. But we will find out probably over the course of the next decade or so whether the Kaler analysis is a one-off or whether it can be applied in other circumstances. Strict and respondeat superior liability are two where we will see this raised in the future. What happens, we will have to only wait and see. Thank you.
Thank you, Paul. Wonderful presentation, very informative. And we'll come back with questions and do a little bit of crosstalk among the panel before we take the audience's questions, which again, we invite you to submit either through Zoom, Facebook, YouTube, or Twitter, where our hashtag is hashtag Cato SCOTUS. Jay, let's talk about Hernandez v. Mesa. In that case, U.S. Border Patrol agent shot a 15-year-old Mexican boy in the face across an international border and killed him. That boy's family filed a wrongful death suit against the agent, and they're never going to get their day in court. Why? Why not?
So the underlying question in Hernandez v. Mesa is whether the parents of this boy who was shot and killed by a border agent could bring a Bivens suit against the federal officer. To provide just a little bit of background here, Bivens is a 1971 Supreme Court case that said there was sort of inherent in the Constitution a right to bring a damages claim against a federal officer who violated someone, who was alleged to have violated someone's Fourth Amendment rights through effecting an illegal search. Now, with regard to state and local officials, Congress passed a statute in 1871 that we generally call Section 1983 that explicitly creates a federal cause of action against state and local officials that violate someone's constitutional rights. But Congress has never passed such a statute with regard to federal officers. Nevertheless, in Bivens, the court said there's sort of an inherent right to bring a damages claim against a federal officer. And the court extended that doctrine to a couple other contexts, one involving a Fifth Amendment due process claim against a government official alleged to have engaged in unlawful discrimination, and an Eighth Amendment claim in the prison context. But since then, the Supreme Court has been very reluctant to extend Bivens to new contexts. And that's where we come to in this case, where the question is, should a foreign national be able to bring a Bivens suit against a border official for a cross-border shooting? And in a 5-4 decision, with the so-called conservatives in the majority and the liberals dissenting, the Supreme Court held that there is not that they will not recognize a Bivens remedy in this context. The way that the majority, which is written by Justice Alito, goes about analyzing this is they start by pretty candidly acknowledging that Bivens was, quote, the product of an era when the court routinely inferred causes of action that were not explicit in the text of the provision that was allegedly violated. So the majority is already sort of saying that, look, Bivens was a product of a different time when what we would now consider basic principles of textualism weren't as routinely followed by the courts. So Alito says there's a two-step inquiry for new Bivens claims. First, is this a new context? And second, if so, are there any special factors that counsel against the counsel hesitation for extending Bivens? And he answers yes to both of these questions. Alito says, even though the original Bivens case did involve a Fourth Amendment claim, this is an entirely different factual context because this is a cross-border shooting, which is very different from a sort of run-of-the-mill unlawful search, domestic unlawful search by a federal officer. And he then says that there are several factors counseling hesitation, the first being the potential effect on foreign relations. This shooting became an international incident, and there was a disagreement between the United States and Mexico over how to proceed. The DOJ did investigate the officer who committed this shooting, but declined to bring any charges or take any other action against him, whereas Mexico wanted him extradited to be tried for murder in Mexico. So given this diplomatic tension, Justice Alito says, look, we shouldn't get involved here. We shouldn't try to arbitrate this dispute that will sort of just disturb the diplomatic relations here. And he also raises a national security interest that, given illegal cross-border traffic, border agents, the conduct of border agents has a strong connection to national security. And finally, he looks at a number of other federal statutes, including Section 1983, which generally do not permit foreign nationals to bring damages claims against federal officers. And so he says, look, Congress knows how to do this if they want to, so we shouldn't extend a remedy here. Justice Thomas, joined by Justice Gorsuch, concurred and basically said Bivens should be reconsidered altogether, that the methodology producing it was incorrect, and it's already been quite limited, and it's time to get rid of it. And then Justice Ginsburg, joined by Breyer, Sotomayor, and Kagan, dissented, arguing first that this was basically the same context as Bivens, that this was an alleged illegal seizure by a federal officer, but that even if it was a new context, it doesn't raise the same foreign relations concerns because this wasn't a foreign relations policy at stake. This was simply a rogue officer acting contrary to federal law. So that's where the Supreme Court ends up on this and says there's no Bivens remedy. And I think that if you look at this through a very narrow lens and just think about this purely in terms of Bivens, it probably seems like a fairly straightforward, maybe not especially important case, because Bivens is on some shaky ground under the sort of principles of textualism and originalism that have a lot of pull with many of the justices on the court now. And the court has already been limiting this doctrine for several years, and this, in some sense, is a recognition that Bivens isn't going to go any further than it currently does. And if Congress wants there to be damages cause of action against federal officers, they need to pass a statute doing so. But I think what makes this case a little bit more complicated and interesting is when you put it in the context of several other accountability-related doctrines that the Supreme Court has created and enforced over the years, which really add up to the government always wins when it comes to accountability. And I would say the most important doctrines there are qualified immunity, absolute prosecutorial immunity, and the Monell Doctrine, which limits the ability of individuals to sue municipalities for constitutional violations. And what I think is interesting here is that if you look at the majority opinion and the concurrence in Hernandez v. Mesa, it seems like a very straightforward textualist, we're not going to create new causes of action, we can't engage in policymaking, we just have to enforce the law as it is. But that attitude doesn't govern any of these other accountability-related doctrines. As I've written about and argued extensively elsewhere, qualified immunity, which makes it extraordinarily difficult to bring causes of action against state and local officials, is not something that is provided for in the text of Section 1983, nor is justified by the history of suits against government officials. Just so with absolute prosecutorial immunity, which makes it impossible to sue prosecutors for constitutional violations. Again, not something that's textually or historically supported, but was essentially invented by the Supreme Court given what they viewed as policy concerns with individuals suing prosecutors. And then in the Monell context, there certainly is a very well-established rule in the common law of respondeat superior, which means that generally employers are liable for torts committed by their employees in the course of their work. And yet the Supreme Court rejected the application of that doctrine to Section 1983 suits and said municipalities are not liable under a respondeat superior theory, but rather you have to show that there was an official policy or practice that led to a violation. So what I think this indicates is that textualism and originalism and very straight, cross your heart and well, we're only going to apply the law principles don't get applied even-handedly, even by the court's so-called conservatives when it comes to the question of accountability. Now, to be fair, Justice Thomas did dissent from the Supreme Court's recent denial of cert for questions in a case raising the question of whether qualified immunity should be reconsidered. And he was very clear that, look, this doctrine does not have a statutory or historical basis, so we should reconsider it. But none of the other justices joined him, not even Justice Gorsuch, who joins Thomas in his concurrence in this case, saying that Bivens should be reconsidered. So I think that there's a bit of a double standard going on in terms of when and how these seemingly objective judicial doctrines get applied. And it always seems to line up against individuals seeking to vindicate their constitutional rights. And then finally, I would just note one other thing lurking in the background of this case, and this is an issue that Professor Vladeck discusses in more detail in his article, is the idea that the historical remedy for constitutional violations committed by federal officers was state tort law. So if an officer committed an unconstitutional search or seizure, they could be sued for a trespass violation or for battery. That's the main way that individuals vindicated their constitutional rights in the founding era. And in a 1988 decision, the Supreme Court said, yes, those remedies are still available against federal officers. But Congress responded by passing an act that we generally call the Westfall Act, named after that Supreme Court case, that makes the Federal Tort Claims Act essentially the exclusive remedy against federal officers alleged to have committed constitutional violations. And of course, there are lots of other limitations in the Federal Tort Claims Act that makes it difficult to hold officers accountable. And Professor Vladeck develops an argument that this act raises significant due process concerns itself, that this may be unconstitutional by, in many circumstances, depriving individuals of any ability to vindicate their rights unless they can fit their claim into a Federal Tort Claims Act. So all of these doctrines work together to make accountability for government officials extraordinarily difficult to achieve. And if you look at this case on its own, it may seem pretty straightforward, and the court may seem to be applying a pretty straightforward textualist historical analysis. But those same doctrines don't get applied in other contexts, and so I think it's worth thinking about how seriously the court is really taking that when it always seems to line up against individuals seeking to vindicate their constitutional rights.
Thanks, Jay. Well, it's a case involving troubling facts, troubling result, troubling rationale, and a troubling context. I'm not sure what's worse than a hat trick of injustice. I guess maybe it's a grand slam of injustice. We'll come back to that in in the crosstalk and the Q&A, I'm sure. I want to remind our audience that we invite you. In fact, we eagerly invite you to submit your questions online through Zoom, Facebook, YouTube, or Twitter, where our hashtag is Cato SCOTUS. And last but not least, Dr. Nicholas Mostick has a surprise in store for us about the Ramos versus Louisiana case. This is a case involving the question of whether the Constitution requires jury unanimity from state criminal juries, a question that the Supreme Court originally answered in the negative. I would say there was widespread a consensus that that was incorrect. And almost everybody that I've read commenting on the Ramos case acts as if the underlying issue itself was a no-brainer. The only question was whether precedent and respect for stare decisis militated in favor of not overruling the DACA precedent. Dr. Mostick has a completely different take for us, and I'm very eager to hear him describe it. Please take it away.
Well, thank you, Clark, for that introduction, and thank you to the Cato Institute for inviting me to participate, and especially to Trevor Burrus, my former co-legal associate at Cato, who's now the editor of the Cato Supreme Court Review. I'm honored to be part of this panel. And yes, as Clark noted, I believe our article is a bit of a surprise. So myself and my co-author, Mitch Mosvik, we approached the Ramos case, I think like most people did, by coming in with both a normative assumption, but also a constitutional interpretation assumption that the lead opinion was accurate in saying that the Sixth Amendment, through the text that says right to an impartial jury, included the right to a unanimous jury verdict, and that this applied to the states through the 14th Amendment. So what surprise do we have in store? What surprised us? I think what surprised us was the history as we got into it. So before I get to that, I think it's worth just reviewing the facts of the Ramos case itself. So I said the basic holding of the majority opinion, which, as I noted, is a lead opinion. That's because it's split. But the split, is Clark, I think, referred to, is mostly about stare decisis as opposed to whether or not unanimity is required under the Sixth Amendment. In any case, this case came out of Louisiana. And so before the Ramos case, there's only 2 states in the United States that still had rules permitting supermajoritarian or non-unanimous jury verdicts, which are 10-2 verdicts. And that was Louisiana and Oregon. This case came from a 2014 murder in Louisiana. Mr. Ramos was identified by the nephew of the victim. There is DNA evidence that was found connecting him to the murder, and he was charged and indicted by a grand jury. And then the jury, by a 10-2 verdict, found that he was guilty of murder, and he was sentenced to lifetime imprisonment without possibility of parole. He appealed that decision on multiple bases, but one of those, of course, was that the verdict itself was unconstitutional because it was not a unanimous verdict. And that takes us to Ramos. So I want to say from the outset that our main goal here was not necessarily to criticize Justice Gorsuch's lead opinion or to say that he was mostly wrong. I think we actually think that a lot of what the court says is accurate. But instead, what we wanted to do is to highlight that given that Justice Gorsuch took an original public meaning originalism approach to this case, he says that in the case, that we think that there's a lot of history that was left out of this discussion. And as Clark says, that is kind of the way that Gorsuch comes into this opinion is a way I think a lot of people did, which is this assumption that this was the most clear conclusion available. So we want to do a couple things. So the first was to compare this to the Heller opinion. So that's Heller versus District of Columbia. That's Justice Scalia's 2008 opinion, finding that the Second Amendment protects the right of individual of individuals to own handguns within the home. And we believe that the Ramos opinion is very similar to the Heller opinion in a number of ways. And you might think of that as kind of three different sections that they look at in order to answer the question that they're looking at. That's this pre-ratification history, which a lot of that is the English common law, and particularly Blackstone's commentaries, amongst others, that are used as sources to establish what is a pre-constitutional ancient right of English liberty. The second is to look at ratification itself, and this particularly means the debates over the text in the Bill of Rights, including textual changes that were made. And then lastly is post-adoption treatises. This idea that treatises after the ratification of the Constitution confirmed a certain interpretation of those amendments, right? So that's the basic comparison to Heller. But rather than spend a lot of time looking at that opinion, the focus we wanted to have was on 3 points about the history that is not really talked about by any of the opinions. There's 5 opinions in Ramos, but really most of the briefs ignored a lot of this as well. The first piece of history is the experimentations in colonial America before the ratification period. And a lot of this history comes in the 17th century. If you look at this period of time in which a lot of the colonies were founded, it's a time of wide, diverse experimentation in what jury trials look like. And in fact, that included experiments in places like Massachusetts, which was essentially a theocracy at the time, as was the colony of New Haven, which would later merge to become the colony of Connecticut. And both of them, for a period of time, did not have jury trials. They simply abolished them. Other colonies experimented with non-majoritarian verdicts. One of them is the state I'm in now, that's Pennsylvania, which came out of the Delaware colony, which eventually split into 2 colonies, as well as New Jersey, which eventually split into New York and New Jersey. So there was experimentation there. And then there was in the Carolinas as well. And what's amazing is that the original 1669 Carolina Constitution was written by John Locke, the great classical liberal theorist who may have been the most important influence upon the founders. I say that only because some scholars believe that, of course, is a source of dispute. But in any case, Locke is an important, venerated figure. And when Locke wrote a constitution, this is the only one that he drafted, rather than the rule of unanimity, he actually followed the rule of a supermajoritarian verdict in criminal jury trials. So that's one part, right? That's the diversity of experiments in the early American period. The second point is about the history of procedure. And I think our big point here is that if you look at 18th century and even 19th century trials and their characteristics and conditions, what they actually looked like, they look very different from how they look in the 21st century. And as a historic point, this is just about bringing context back to this discussion. So if you, in other words, if you remove just unanimity from all these other conditions of a jury trial in 1791, you lose some perspective. And I think the most important point is that in this period of time, judges had an awful lot of control over juries. One of the ways that they had control is that criminal defense lawyers were often not even present in court, and in fact weren't really statutorily guaranteed until 1836 in England. And judges could do many things in order to force the hand of the jury. They could force juries to re-deliberate. They could terminate a jury early if they believed that they were going to find a verdict that the judge disagreed with or did not like. And they could also coerce a jury, which means that if there were a couple holdouts that were preventing unanimous jury verdict, they could withhold food, shelter, light, all sorts of things from juries in order to force them to come to a decision. And this is something that started at the very beginning of the 14th century when we see the arrival of unanimous jury verdicts, but it continued well into the 19th century, even in the United States. There's a New York Supreme Court decision from 1898 that at length testifies to this throughout the United States still being a problem. So that's the procedural history. And then the final point is one of judicial critics and scholars, right? So I mentioned these post-adoption treaties that are used in the Ramos opinion. And I think what we found was two things. One is that some of those treatises that are cited actually are the source of some criticism, both normative criticism and at times other criticism that possibly the rules should be done away with, which includes John Norton Pomeroy, for instance, his treatise. The others include even critics like Jeremy Bentham, Chancellor James Kent of New York, and I think most prominently in our research, Francis Lieber. So Francis Lieber is most well known, the German-American jurist, for writing the Lieber Code during the American Civil War, which is really the first modern set of law of war in America that really set the boundaries for how the war should be conducted. And in 1867, Lieber sent a letter to the New York Constitutional Convention. And in that letter, he proposed that they adopt non-unanimous supermajoritarian verdicts in both civil and criminal contexts. I think what's amazing about Lieber's letter is that he does mention the Constitution, but he doesn't mention the Sixth Amendment at all. And this is something that you find common in a lot of these treatises, and both critics and supporters of unanimity. What Lieber does talk about is double jeopardy. And his point was that there could be a double jeopardy problem because there's so many hung juries that were the result of unanimity being a rule. And the problem with hung juries is it suggested that there were jurors who had doubt about the criminal guilt of the defendant. And that as a result of the retrial, the defendant was now facing jeopardy to their lives more than once. But the real point of that criticism, I think, was that Lieber felt that the ideal of a unanimity could not be met. And when he said that, he actually reflected a lot of these writers, even those who ended up supporting unanimity, is part of the criticism, in that this idea of 12 free, conscious individuals, like 12 angry men, coming to a consensus was not in accordance with the full and greater history of the rule and of jury trials more generally.
Great. Well, thanks, Nicholas, and thanks to all three of you for your fascinating explanations of some complicated, in some cases, troubling cases. I'm going to exercise the moderator's privilege of asking one question of each of you. I'm going to go in reverse order since Nicholas's commentary is kind of most fresh in our mind. I also want to thank the audience. We've been getting some excellent questions, and we'll get to those in just a moment. But I will remind you, if you're just joining us, that we invite you to submit questions through Zoom, Facebook, YouTube, and Twitter, where our hashtag is Cato SCOTUS. So Nicholas, let me ask you this question. How issue specific is your analysis? And let me provide a framework. There are other attributes, it is considered that there are other attributes of a Sixth Amendment compliant jury. One of them would be numerosity. The Supreme Court has said that there's a certain number of jurors you cannot have fewer than. You could not have a valid verdict from a four-person jury. That is just too few. I would argue that perhaps deliberativeness is potentially a Sixth Amendment requirement of a jury. In other words, a jury that delivers a verdict after being forbidden and prevented from deliberating among themselves, that verdict might be invalid. And then finally, does your analysis suggest that perhaps a verdict from a bare majority, that if a state just wanted to have, let's say, an 11-member jury and 6 votes for guilt are sufficient, would that, in your view, be consistent with the history that you've examined? So take as much or as little of that as you want, but I'd love to hear your views.
Yeah, so I'll go ahead and start with the last point, since I'll go in the same reverse order that you did, since that's easiest. And I'll say that there are not many critics or those who discuss unanimity who support a 7-5 majority verdict. I may have seen it once or twice, but generally speaking, when commentators are talking about supporting non-unanimous jury verdicts, they're either talking about 9 out of 12 or 10 out of 12. And I've even seen 11 out of 12. I think President Rutherford B. Hayes, he gave a speech in 1889 supporting a change to the rule. I think Hayes actually supported 11 out of 12. Just saying even one person dissenting, that would be acceptable. So I think maybe the point there would be there's room for debate. There's uncertainty there, and I think that's part of what I'm getting at. And I think the background argument is this ability of states under federalism to have room to experiment with their criminal procedure, at least some room, right? I think typically we see this in a lot of how we understand federalism, that there are limits, but our ability to precisely draw those is hard. But I don't think that there's as much evidence to say people advocated for bare majorities. I don't think you see a lot of that. Deliberativeness, I don't know how much I saw that really come up. So I don't want to comment on something that I didn't really see a lot of evidence for. The 12 jurors, that definitely is something that you see come up in connection with discussing this rule and whether or not it is required. If you look at Williams versus United States, for instance, which is the Justice White opinion before Apodica in 1970, one of his arguments is that and unanimity are both part of these common law rules at the time of the founding that he didn't think were necessarily constitutionalized as fundamental aspect of the trial by jury. So again, you do see a connection between the two. I think that again, there's this concept in federalism, right, that some of these critics are arguing for, which is that there should be an ability to some extent to experiment. But there's a limit, right? And I don't know if we'd say that's obvious or not, but you couldn't just have 4 jurors, right? You couldn't have no deliberation. So there's in other words, it seems like there's a de minimis expectation that's almost assumed by everybody in the discussion. So what they're really getting at is sort of these tighter margins, right? About whether or not 9 or 10 is sufficient, because they're, I think, essentially assuming it's a jury of 12. Because everyone also recognizes, if you read the treatises, that the 12 is a magic number. We don't really know exactly where it came from. It probably came in 1166 out of Henry's Azizas. It may have came later, but it largely is probably a historic accident. And so if we follow it, I think, at least according to the treatise writers, it's because we think it's a good number as much as anything else. And that is partially part of the criticism too, is whether or not unanimity itself is just a historic accident being treated as this ancient right that has always been there, if that makes sense.
It does, and thanks a lot for that very fascinating answer. So Jay, I was going to ask you a question out of my own head, but someone beat me to it from Twitter, and I'm going to read it verbatim because I think it's so beautifully phrased. The question from Twitter: can you please explain the doctrine of qualified immunity and why the Supreme Court has yet to abolish qualified immunity despite the increasing public outcry about the lack of accountability for police misconduct? For those who don't know, Jay is actually heading up Cato's campaign to eliminate qualified immunity. And that was an issue earlier on in the Hernandez v. Mesa case. And in fact, the case went to the Supreme Court before the case that Jay discussed, which was the second trip to the Supreme Court. And the first time it went up, it involved qualified immunity. So Jay, there's the stage. There's the not breaking slow ball right over the middle of the plate. Feel free to take it into the upper deck.
Sure. So qualified immunity is a judicial doctrine that the Supreme Court invented in the 1960s and then kind of crystallized in the 1980s. That in theory is an interpretation of the federal statute that I mentioned in my opening remarks, Section 1983, which creates a cause of action against state and local officials who violate someone's constitutional rights. And that statute doesn't say anything about any immunities, but the Supreme Court has interpreted that statute to basically say that it is not enough for a civil rights plaintiff to show that their rights were violated. They have to show that the defendant violated clearly established law. And that phrase, clearly established law, is really the key to understanding qualified immunity. Because although it might sound reasonable enough in the abstract, the way it is practically applied is that before an individual can get redress for a constitutional violation, they essentially have to find a prior case already decided in their jurisdiction where someone else's rights were violated in basically the same way. In other words, they have to find a case with functionally identical facts. So what this means is that civil rights plaintiffs are routinely denied justice because even though their rights were violated, there doesn't happen to be a prior case where someone's rights were violated in quite the same way. And the reason I think that this is important to consider along with Hernandez is that, as a doctrinal matter, qualified immunity applies both to Section 1983 suits, i.e. suits brought under this statute against state and local officials, as well as against federal officials in Bivens cases. And what is actually kind of bizarre is that the case that created the clearly established law standard, Harlow versus Fitzgerald in 1982, and which really created the modern doctrine as we know it, was a Bivens case. And yet at the very end of the opinion, the Supreme Court kind of drops this footnote and says, oh, and of course the same standards will apply to Section 1983 suits. So when the court made up this doctrine, they clearly weren't even trying to interpret the statute. They were just making policy decisions. And whereas, given that Bivens is kind of a common law doctrine on its own, maybe it's a little bit more sensible to have this kind of common law defense. But I think, what's important to keep in mind is that this, when the Supreme Court is limiting the scope of Bivens, it is acting in a very textualist historical way, or at least trying to. But then when the Supreme Court is extending qualified immunity, it's ignoring all of that. Now, as to why the Supreme Court hasn't fixed it, I don't have a definite answer for you. I think we, tried to give them a good opportunity to do that at the end of this last term, but only Justice Thomas seemed interested. Part of the explanation may be that Congress has recently started taking up this question and been discussing a federal legislation that would eliminate or modify qualified immunity, but nothing has come of that yet. But it's hard to say. And I think that the Supreme Court warrants criticism for its what I would consider half-hearted, the government always wins approach to textualism when it comes to these sets of accountability doctrines.
Thanks, Jay. And Paul, I've been dying to ask you this question, and I'm going to ask you to assume that your yellow light is on. So maybe take a couple of 2 minutes, if you can do it in a couple of minutes. You very articulately and persuasively suggested, I think, that the facts in Kaler almost could not have been less sympathetic. But let me change the facts somewhat and ask you to comment on what if it had come up in a different context? Imagine someone grew up as a feral child. Literally, they were discovered in the wild, maybe at the age of 17 or 18. And at some point after their 18th birthday, so there's no infancy defense here. There's an incident where they're out with friends, someone grabs one of their French fries when they're having lunch at McDonald's, and the formerly feral child person reacts with extraordinary violence and seriously injures the person who just playfully grabbed a French fry. And the explanation for that is that in the circumstances under which that person grew up, you must never allow somebody to take even a morsel of food from you, or you'll effectively never get to eat again, and you'll be at the mercy of the most powerful people in your tribe, or whatever. That's an example where somebody really doesn't get that what they did was wrong, or at least there'd be a very persuasive argument for that. Might that have changed, if that had been the case, might that have changed the outcome in Kaler? And if not, you've suggested, I think, that maybe the proper recourse to prevent either the application of any punishment or at least a severe punishment under circumstances as sympathetic as the one I've just described might be the Eighth Amendment. Would you care to weigh in on this much more sympathetic fact pattern that I've given you?
Certainly, and I will try to be concise. First, in the case of the feral child, there's no mental illness involved, so there can't be a insanity defense in the normal understanding of it. What you would have to do, in effect, is raise something akin to a cultural defense, if you will. And then you run in headlong into the problem of distinguishing that case from honor killings and the like. The problem with insanity has always been that a person, because of mental disease or defect, is incapable of doing anything else. This is a person you've mentioned who is not incapable of doing anything else. The person just hasn't been taught what the rules of the road are. Now, that may be a problem for one reason or another with the way the person was raised, but once the person moves out of that environment and is into the environment with the rest of us, society is entitled to say, you no longer were incapable of conforming your conduct to the requirements of the law. You just either weren't told what they are or were not permitted to do so. Now, if what you're saying is this is a classic example of a strict liability type of crime because the person is doing something for which he or she had no understanding of what the circumstances are, you have to raise it in that context. You would have to persuade the Supreme Court to walk back from its jurisprudence in this regard. Maybe you could, but you would have to do it that way and do it in a way that distinguishes, the honor killing phenomenon, because there is under American law no cultural defense like this available. Secondly, as to the Eighth Amendment, the problem with using the Eighth Amendment is in the very text of it. The Eighth Amendment talks about punishments, not the definition of crimes. The question is really more whether the punishment imposed on that person is cruel and unusual, not whether the crime definition is cruel and unusual as applied to that person. Now, I've argued that although the Supreme Court has upheld the constitutionality of convicting someone of a strict liability crime, it has never confronted the issue whether that person can be imprisoned, and if so, for how much. So maybe the best example would be someone who is convicted of that offense you mentioned and sentenced either to a very long term of imprisonment or sentenced only to a fine. The Eighth Amendment might not prohibit somebody from being fined in that regard, because it certainly wouldn't prohibit a tort action from going forward. And all we're talking about is the name of the plaintiff. It's the state rather than John Doe. Whereas maybe there's a different circumstance if that person were given a sentence of life imprisonment. I doubt it. But nonetheless, it does raise that sort of problem. And only the punishment, however, will be relevant under the Eighth Amendment.
Thanks so much, Paul. I appreciate that response. All right, we got 7 minutes left, and we're going to do a little bit of a rapid fire here. Jeff Walden asks a question that I myself wondered when I read Justice Thomas's opinion in the Ramos case, and maybe Nicholas can enlighten us. Why did Justice Thomas, or why do you think Justice Thomas based his decision on the Privileges or Immunities Clause of the 14th Amendment when the 14th Amendment also prohibits the states from depriving anybody of due process? And it would seem that the procedure by which a state tries you for a crime and convicts you of a crime, whether or not a jury has to be unanimous, would seem to fall under the rubric of due process. Why go mine the Privileges or Immunities Clause instead?
Yeah, I think that's a great question, because it's a reminder that a lot of the early cases in the Supreme Court that commented on unanimity were Fifth Amendment cases towards the end of the 19th century and the early 20th century, both from states and territories. So I think that's a good question, because my sense is that what Justice Thomas was mostly doing is continuing what he started in McDonald, which is a desire to move on from incorporation under the Due Process Clause and shift towards incorporation under the Privileges or Immunities Clause. So I think it's just simply, I view it as being more linked to a broader project that Justice Thomas has. But I think it's a smart question, and I'm not sure how well Justice Thomas actually answers it in his concurrence.
Thanks a lot. Jay, I'm going to warn you in advance that you might take issue with the premise of Chip Parkhurst's question, but I'm going to read it verbatim and let you take a crack at it. Chip asks, does the relative rarity of qualified immunity make it less likely for the Supreme Court to consider it a procedural mess that's even worth cleaning up?
Yeah, I mean, I'm a little unsure what relative rarity is supposed to mean in that context. I mean, it is certainly the case that, you know, in the majority of Section 1983 suits, qualified immunity doesn't come up. This is something that Joanna Schwartz has looked at in quite a bit of detail when she showed that qualified immunity was actually only raised in about a third of the cases where it could, in principle, be raised by law enforcement defendants. But that doesn't indicate that the doctrine isn't having a powerful effect. The conclusion that Joanna Schwartz draws from that result is that for the genuinely non-meritorious lawsuits, and of course there are many non-meritorious lawsuits, other tools of civil procedure are sufficient to dismiss them. But when qualified immunity is raised, it is an incredibly powerful defense. And our research indicates, this is sort of a synthesis of scholarship by Chris Walker and Aaron Nielsen, and a recent Reuters investigation, that when qualified immunity is raised, courts grant it well over half the time. So I don't consider it rare because it is playing a powerful role in exactly those cases where there is a plausible constitutional violation, but it's coming up in a somewhat new factual context. That is exactly the set of cases where you want courts deciding these merits questions to make clear what the scope of constitutional rights are. But when courts apply qualified immunity, not only does that person get denied compensation, but courts don't even actually have to address the merits question. They can simply dismiss because there's no clearly established law, which therefore doesn't create more clearly established law. So I don't think the Supreme Court views this as rare. I think the Supreme Court, at least in its recent opinions over the last decade or so, sees qualified immunity as a very important and active doctrine. They have aggressively reversed lower courts that deny immunity to government officials because they wanted to send a very clear message that courts should think twice before ever denying immunity. So, you know, which way that cuts in terms of whether it should be reconsidered, you know, depends on your underlying views about qualified immunity. But I don't think the doctrine is a rare one or one that has little effect.
Thanks. Hey, Paul, Jack Brown asks whether the hypothetical involving the feral child who didn't know the rules of the road raises any implications about the old legal maxim that ignorance of the law is no excuse for a crime of which you've been accused. Part of the historical justification for that maxim was the assumption that people could and did know the law. But of course, that maxim arose at a time where there really weren't very many laws on the books. They tended to relate to things that were very obviously morally wrong, like murder, arson, and things of that nature. Have we maybe entered an era where the old legal maxim of ignorance of the law is no excuse is more and more difficult to sort of justify or reconcile with our constantly expanding criminal code?
Yes. In fact, I have written about this in a variety of different articles. The proposition that everyone is presumed to know the law is actually not remotely empirically justifiable. No one could know all of the criminal code. No one could know all of the relevant regulations. No one could know all of the relevant guidance documents and the like. It is really just a moral statement that we are going to hold people accountable in this regard. The problem is once the law grows tremendously in its size, which it has, no one can know it all. So it doesn't make sense. There should be a mistake of law defense. And I've argued in many contexts that there should be. The problem with it coming up in this hypothetical, however, is this. If you have a mistake of law defense, you have to decide what the elements are. And it seems to me that there should be two. One is that the conduct charged against a person was conduct that no reasonable person would have known to be unlawful. And secondly, that the person, him or herself, did not know that this conduct was unlawful. Now, in the hypo you gave me, which the questioner asked about, the second element would be satisfied. The person did not know that essentially a minor theft like this was a crime. But any reasonable person would have known that what you're essentially doing is, you know, taking, if you will, someone else's property. The question is whether or not, therefore, you have that person has consented to you doing it. That's a different question. The feral child can be held to the standard of what a reasonable person would know is and it's not criminal. And therefore, it doesn't exactly raise the type of problem that you normally see where an official is alleged to have violated some regulation that only a legal expert would know about.
Thanks, Paul. Well, that brings us to the end of the panel. I want to thank all three of you for the excellent commentary and the hard work that you put into preparing and the quality of the articles, which were fantastic. Speaking of which, let's all thank Professor Steve Laddick as well and congratulate him on his recently being named the Charles Allen Wright Chair in Federal Courts at the University of Texas. It's a shame that he couldn't be with us today, but we thank him for his wonderful article, and we hope to see him again as soon as possible. I also want to thank the audience for the really thoughtful and engaged questions. Really made the panel more interesting for me and I'm sure for the rest of the panelists. So thanks for that. And I hope you'll all return after 15 minutes where we're going to roll into panel 3, Potpourri. That will start at 2:15. And with that, again, thank you, panelists, and we're done.
Perfect. Welcome, everyone. Greetings. Welcome to our third panel. Excellent. Potpourri. That was actually my favorite Jeopardy category, so I'm very much looking forward to this. I'll get started by just restating the ground rules. I'll be introducing each speaker in turn. After our panelists have spoken, we'll get straight to audience questions. I remind audience members that you could submit questions both through the Zoom comment feature, but also through various social media, be it Facebook or Twitter. And without further ado, we will get straight to business. Our first speaker today is Keith Whittington. Professor Whittington is the William Nelson Cromwell Professor of Politics at Princeton University. He is the author of 13 books on constitutional subjects, so he's well qualified to speak today. I was amazed to learn that he is currently working on 2 books. He's currently completing 2 books, Constitutional Crises, Real and Imagined, and The Idea of Democracy in America. That blows my mind. I can barely cook 2 Pop-Tarts in the morning, and Keith is writing 2 books. So he will be presenting on the vexing problem of faithless electors, a very topical subject. So please, Keith.
So thank you very much. So my piece for the Supreme Court review was to focus on the faithless electors case that the court heard this past term. As you may recall, in the 2016 elections, a organized movement was launched, which eventually took the label of the Hamilton electors, which was encouraging presidential electors not to cast their ballots for the presidential candidates to which they were pledged. Particularly, the goal was to convince Republican, Trump-pledged presidential electors not to cast their ballots for Donald Trump, but instead to cast their ballots for somebody else. Either with a goal of shifting the election victory to Hillary Clinton, or shifting it away from a simple majority such that the election would be thrown into the House of Representatives. This effort was obviously unsuccessful. Donald Trump nonetheless retained most, although not quite all, of his presidential electors, and did retain the necessary majority in the Electoral College to be inaugurated as President of the United States. Nonetheless, there was a quite dramatic number of presidential electors who did either successfully or attempt to cast their ballots for someone other than the person that they were originally pledged to, mostly Hillary Clinton electors who were pledged to vote for Hillary Clinton who chose to vote for somebody else. States have, over the course of the 20th century, for the most part, tried to adopt various kinds of legislative mechanisms to discourage these kinds of what were called faithless electors, electors who break their pledge to vote for a specific candidate, but instead cast their ballots for somebody else. States have adopted a variety of different mechanisms to do this, and 2 different mechanisms were deployed by states during the 2016 presidential election that eventually gave rise to litigation that eventually reached the U.S. Supreme Court. One set of cases came out, one case of the 2 cases the court heard came out of Colorado, involving Hamiltonian electors there. In Colorado, the statutory mechanism that was in place at the time and then used was one of removing presidential electors who refused to cast their ballot in a way that they were previously pledged, and replacing them with new presidential electors who would cast the ballot in the expected way. The state of Washington had at the time a slightly different mechanism. That is, they imposed civil fines on faithless electors. Traditionally, these have been mostly symbolic efforts by the states. The states haven't tried to actually implement these in practice, but both Washington and Colorado did, as did some other states. In 2016, Washington imposed a civil fine on some of its electors. Colorado did, in fact, replace one of its electors. In both cases, those electors subsequently brought suit against those states, arguing that the state laws violated their rights as presidential electors to cast their ballots without constraint. This raises a, actually, I think, quite difficult constitutional problem in some ways. It's a kind of constitutional problem that, of course, the U.S. Supreme Court has not spent much time thinking about, as have other courts have not really spent much time thinking about this all across American history. And moreover, this is a problem that's largely orthogonal to most of the kinds of constitutional disputes that arise in the Supreme Court. And so as a consequence, the justices were in the somewhat unusual situation of really being able to think fresh about this particular problem and not be as divided as they might normally be by a pre-existing set of constitutional concerns or a larger set of political concerns. What they did in this case was not going to affect a presidential election, unlike Bush v. Gore, for example, but would have potential consequences for future elections. The result was the justices were able to all agree on an outcome, in this case, to strike down, to uphold the laws that were in place in Colorado and in Washington and in a variety of other states that are designed to restrict the legislatures, the presidential electors. There was nonetheless some disagreement among the justices as to how best to explain this result. Two of the justices wrote a concurring opinion. The opinion itself was written by Justice Thomas that provided a different explanation than what the majority offered in an opinion by Justice Kagan. Justice Kagan emphasized the notion that the pledge the electors took was part of the condition of the appointment of presidential electors, and states had an authority by determining the manner by which presidential electors are going to be selected to impose conditions on the electors, including this one, and then punish electors if they violate the conditions of their appointment. Thomas took a different approach. Instead, his argument was not that you could find such a power in the terms of the U.S. Constitution itself, but instead it was a reserve power of the states under which was recognized by the 10th Amendment. There was nothing in the Constitution that prohibited states from adopting these kinds of sanctions. I think both kinds of arguments actually have some real trouble in justifying themselves. Both run afoul, certainly, of how people anticipated that presidential electors would behave when the Constitution was created, and really have some real difficulty being reconciled with the language by which the Electoral College sets up, which assumes the existence of presidential electors who appear, at least, to be relatively unconstrained in their ability to cast votes and cast ballots in general. Moreover, the court has now opened the door, I think, to a range of potential problems that are going to arise down the road. On the one hand, I think they gave some support for the effort to build the possibility of a national popular vote structure for the presidential electors. States, I think, under this decision have clear authority to require the presidential electors support whoever wins the national popular vote rather than who supports the statewide vote, and presumably now have more authority to punish electors who do not adhere to the national popular vote, or even replace electors who refuse to cast ballots consistent with the national popular vote. But it wouldn't surprise me if we don't wind up seeing a future case in front of the U.S. Supreme Court if we get that kind of state compact in place that resolves that challenge more clearly. Moreover, it opens the door to the possibility of states adopting other kinds of requirements on presidential electors. For example, it raises questions about, can states require that their presidential electors only support, only cast ballots for presidential candidates who have publicly released their tax returns, for example, or only cast ballots for presidential candidates who are part of a gender or racially diverse ticket, for example. And you can imagine a host of other possibilities states might adopt under this new approach. And they will raise challenges that ultimately I think the court will have to resolve to try to explain how those kinds of conditions relate to these conditions. On the other hand, the court avoided upsetting the current expectations about how presidential elections work, and the current expectations that faithless electors are behaving inappropriately. The states have tried to discourage faithless electors, and this decision will allow states to continue to try and discourage faithless electors, and didn't lend any rhetorical or conceptual support to future presidential electors who might want to behave faithfully. And that's at least a win for the stability of the presidential system and the electoral system as we know it. So let me end there so we make sure we have time to get to lots of questions.
Excellent. Great stuff. Thank you, Keith. Our next panelist is Robin Fretwell Wilson. She is the Mildred Van Voorhees Jones Chair in Law at the University of Illinois College of Law, where she specializes in family law and health law. Now, as with Professor Whittington, Professor Wilson has also written 13 books. I mean, that's amazing. 26 books between the two of them. I also learned this in researching her bio that I thought was very cool. Professor Wilson, she is a co-investigator with the faculty at the Bar Ilan University in Tel Aviv for a project to identify the impact of COVID-19 on children and families. I thought that was a really interesting nexus of law and science. So without further ado, Professor Wilson will be presenting on the article, The Administrative State as a New Front in the Culture War, Little Sisters of the Poor v. Pennsylvania, an article she co-wrote with Tanner J. Bean. So please, Professor Wilson.
Thank you, Will. So the first real challenge is to see if I can share screen. If we get that far, we're in good shape. Okay, can you guys see that, Will? Okay, so you'll see a picture of me with the Little Sisters. I want to start off by saying that I have great respect for them. They do amazing work in the world. And so bless them for what they're doing. They've been dragged through a lot. I want to try to give some context for that. And then I want to argue that even though they rack up a 7-0 victory at the Supreme Court in their favor, that this is likely to be a lull in a larger culture war storm about the rights of women on one side to have the ability to control their reproductive access and the rights of religious objectors and moral objectors to step off. So we're all starting from the same place. There's a longer arc than just the Little Sisters. And this is beginning with the Affordable Care Act, at least in one account, it starts with the Affordable Care Act. So you'll see this paragraph. It's the paragraph in the Affordable Care Act, which was 440,000 words. This paragraph sparked the culture war that gave us Hobby Lobby, that gave us Zubik, and now has given us Little Sisters of the Poor. It essentially vests in a sub-agency within HHS the ability to decide what drugs women and any employees would be guaranteed as preventative care services under the Affordable Care Act. Now, HRSA, this Health Research Services Agency, came back with 30 drugs. And 4 of them were stipulated, and you can see on the left, were stipulated to work on the implantation site. In fact, the FDA label said that, and I'll show you that in a second. Many religious people then rejected, the idea that they would pay for this, and many people rejected the claim that religious people made that this was somehow causing them to end a life, as opposed to simply being contraceptive or preventing a life. There are plenty of objectors who objected to both. I'll show you that in a second. So the basis for that technical scientific concern actually came from the FDA labels themselves. It was ultimately stipulated to in litigation. Many people reject the idea that some of these drugs work at the implantation site. There are peer-reviewed articles that talk about that. But for the moment, we can bracket the scientific debate about how they work because the government conceded that when objections were raised. Then we had the set of religious objectors, many of whom filing under our friends, the Beckett Fund for Religious Liberty, claiming that they would exit the market, they would close facilities if they were forced, in fact, to pay for these abortifacients. We had Archbishop Lori appeal to a longer tradition in the United States to leave moral and religious objectors to the side when it came to abortion, and he appealed to the morality of not forcing one person to violate their religious objections in order to help another. And then President Obama took a first stab at a fix for these two competing tensions. Actually, I think he got it pretty much right. He said, we're going to leave the religious nonprofits to the side of this duty, but we will make sure that women can still get these drugs with no wait, no hassle. And in particular, what he does is he dragoons an insurer, the insurer that runs the federally facilitated exchange, to pay for these drugs on behalf of the objecting nonprofits so that they were not required to pay. Now, well, just to make that very concrete, I use the iconic example of Notre Dame in one of my articles. Notre Dame has 16,000 plus employees. If Notre Dame objects to providing these kinds of drugs to its employees, the federally facilitated exchange insurer will pay for it. So Notre Dame's employees are not left without. Notre Dame doesn't pay. Everybody goes on, I guess, no harm, no foul. And then we all remember Hobby Lobby. Hobby Lobby was one of the first step overs to the Supreme Court on this. Hobby Lobby did not qualify for the kind of Obama fix because they're not a religious nonprofit, they're a closely held corporation. I doubt that they would have accepted that fix willingly, given the nature of their religious objection, but they didn't qualify. So they sue under the Religious Freedom Restoration Act, as we'll all remember, and a decision comes back that there was a less restrictive means to making sure that the government gave access to women to preventative care services without forcing Hobby Lobby to do it, namely to extend the Obama fix for religious nonprofits to Hobby Lobby. And that ultimately happens at the end of the Obama administration. Then enter the Little Sisters of the Poor. They don't want the Obama fix or the thing that was being done for religious nonprofits, although they would qualify. They want nothing of the outcome. In other words, that women would have these drugs available to them. And so begins this round of litigation. We have a brief stopover in Zubik, where the Supreme Court seems to, at the end of the Obama administration, say, really? We can't all get together and agree on how we can both take the Little Sisters out of the equation and make sure that women get these drugs. And for a period of time, it looked like that might happen, but it proved too much in the waning hours of the Obama administration. And then I think, to the surprise of many people, the whole thing flips to President Trump. And one of his earliest acts, he says to the Little Sisters in the Rose Garden, don't worry about it, I've got your back. And his own departments leave in place, interestingly, the mandate for everybody else, but then start carving big holes in it. One, a wholesale exemption for any religious employer. And then second, a completely new moral exemption. In other words, if you are morally objecting to these drugs because you see them as an abortifacient, you don't have to pay. Now, what is different about this than what President Obama did with his fix is that there is no provision made for women. In other words, these groups are now treated the way the Obama administration narrowly treated churches. The claim in the Obama administration was that anybody who worked for a church would share that church's views. So basically there was a no harm, no foul, a kind of a null set of people who went without because of it. That can't be true when you look at an employer that's as large as, let's say, a Notre Dame or a Hobby Lobby. There was going to be a mismatch between, for many employees, their employer's view. But in any event, that's where we land. And then that, of course, kicks up litigation by 2 states, which takes us to the Little Sisters decision issued this summer. But Pennsylvania and New Jersey cry foul. They say, wait, if you're not going to pay for this stuff for these religious and moral objectors, then we will have to. And so that's our interest in complaining. And then I will just make the recitation of the case very brief here. It all lands on these 3 little words out of 440,000 in the ACA. And that is specifically as provided for by HRSA. So in a decision written by Justice Thomas, he says that those words authorized, Congress authorized HRSA and the departments to make this thing up from whole cloth, and it authorized them to punch big holes in it at the same time. Kagan, interestingly, signs on, and I think she points away to the fact that this is likely to be an exceedingly short victory. But she says, okay, all true, but we haven't decided whether this is in fact arbitrary and capricious. The 2 states that litigated have already said that they would appeal or start again. And then presidential candidate Biden has said that he'll scrap both of those exemptions. Now I want to talk about the substance of the paper, since we're on the same page, I hope. And I'm going to make a couple of very brief points. One, there's a longer arc of respect for religious objectors, especially to facilitating or paying for abortion in America, stretching all the way back to 1973 and the Church Amendment in 1976. in the Hyde Amendment. And this is a disastrous graphic, I realize, because it's super tiny, you can't read it. But let me make the point that way back here in 1973, with Roe v. Wade, almost at the same moment, Congress said, we'll never make a person do an abortion against their religious or moral objection. They also said, if you want to do them, then you can't be penalized for not doing them either. It's a two-way street, conscience protection. Comes along Hyde in 1976, enduring until now, query whether it will be in the next administration, saying we're not going to make Americans pay for abortion except in instances of rape, incest, life of the mother. And that endures. And then the decision picks up way back on the timeline when we get to Little Sisters of the Poor and what happens with the moral and wholesale exemptions that the Trump administration puts in. But what gets missed is that one of the pivotal things that gave us the ACA were pro-life Democrats like Bart Stupak actually negotiating for the fact that these sort of detente that we've achieved around abortion since 73 and 76 stays stable. And so there is a sense when the mandate comes back from the sub-agency within an agency, and it has 4 drugs that their own labels say may act as abortifacients sometimes for some women, that there was a breach of faith. There was a reason the religious right sort of jumped up. Now, on that point, you can think of the moral and wholesale exemptions as returning America back to where it was just before the ACA and just after. Second big point, Congress, you don't need this slide for that, but Congress could fix this. Congress could in fact write an exemption in for Little Sisters of the Poor and guarantee women access much as President Obama has done. Now, I wouldn't hold your breath on that. I don't see that necessarily coming because I haven't seen a whole lot over there. But the point being that they could do this and take this problem away and stop forcing everybody to litigate over what should be a reasonable outcome. Women have access. We don't make people do it over their religious and moral objections. So that's Congress. Third, the administrative state. This is the sort of tagline of the piece, but we are now going to see culture war fights seep farther and farther down into the administrative state. The effect, I think, will be to incentivize, in fact, culture war moves made by unaccountable actors. Now, we know from this graph, which I left out of my article, but from this graph, we know that political actors are being named to positions deeper and deeper inside of administrations. And these aren't just sort of the old school secretary level appointments and then a stable civil service base. The whole thing is turning over to a greater degree. You know that political campaign workers are being placed in these agencies. And many of them are coming into the position with significantly worked out priors. And that means that they're not really there to interpret the law. They're making law the way they would like it to be. And you can see this sort of yin and yang just on the contraceptive coverage mandate as an example of that. And I'll stop off and say one point about administrative agencies. Our whole explanation for why we should defer to them is that they are like technocrats, right? They have like the scientific knowledge. Congress can't be bothered with the minutia of these laws. Congress isn't as expert as the experts. But when the claim is a moral one, when it's really the valence of it is about the morality of something, that whole explanation for deference falls apart. And then last point, because I know you want me to end. I was sort of curious, like, hey, how much of this is happening in other kinds of statutes? How many statutes have as provided for in them? And so we went and looked across the US code, found a number of examples, and I'll give you one here. And this is my last point. So we regulate federal parks. And in particular, we regulate whether you can hunt in federal parks. And so the background rule in these statutes was to regulate hunting. The president was allowed to describe the sort of scope of those regulations. And then, as provided for by the Secretaries of Interior and Agriculture, there could be exemptions. So imagine that we had these lions in these parks, okay? That as provided for structure after Little Sisters, the case, would allow the Secretaries of Agriculture and Interior to make an exemption, an allowance to the no hunting rule for people, let's say, between 40 and 45 years of age that could pay $100,000 fee. So here's like, for example, one taker one person that I think is willing to pay that fee because we know this guy loves to hunt, right? And then that takes us right back to where I started, which is it's really going to be a question of whether these kinds of concessions would be seen as arbitrary and capricious. And so good luck to the sisters, because I think their long saga, in fact, is not over. And I'll stop sharing screen there.
Excellent. Thank you so much, Professor Wilson. That was great stuff. I Googled our next panelist to research my introduction, and the first result was titled "The Tattooed Libertarian on the Arizona Supreme Court," which I thought was fantastic. This is my sort of guy. As I'm sure most of our listeners are aware, or viewers are aware, the Honorable Justice Clint Bolick has been a luminary in the libertarian legal movement for decades. He co-founded IJ, or the Institute for Justice, which is just fantastic. Again, currently he's serving on the Arizona Supreme Court. I will note this, by my count, he has only published 11 books. So I guess that pales in comparison to the 13 of his predecessors. But I will add this. Evidently, he has published a fiction, a novel, which I thought was fantastic. So without further ado, I will hand it over to the Honorable Justice Clint Bolick, who will be presenting on the dimming of Blaine's legacy.
Well, thank you so much for that introduction. I do have number 12 on the way this December, and if you do add the fiction novel, which is a lot harder than a nonfiction book, in my opinion, we get to 13. First of all, thank you so much to my colleagues on the panel, and also especially to the Cato Institute for honoring the birthday of the most magnificent document in history, and an enduring constitution. And Cato plays such a central role in ensuring that the neutral principles of the Constitution are honored, and that judges who do not honor those principles are held to account. This case, Espinoza versus Montana Department of Revenue, has a huge backstory. And it really begins well over a century ago at another point in our history when we had a tremendous amount of anti-immigrant fervor. And that fervor was personified by a frequent aspirant for the presidency, James G. Blaine, who served as the United States Senator from Maine. And Blaine used his fervor to prevent immigrants from sharing in the public funds that were available for education, which at the time in the late 19th century were really not secular schools so much as they were Protestant schools. And the Protestants did not want to share their funding. And so Blaine proposed a national amendment that would prohibit aid or support using public funds for what he called sectarian schools. Today, when we think of the word sectarian, we think it is synonymous with religion. But at the time, sectarian meant something very clear, and that was Catholic, because the immigrants at the time were primarily from Europe and brought not only their Catholic faith, but their Catholic religion, their Catholic schools as well. Blaine failed in enacting a national amendment, but he was incredibly successful in enacting them in state constitutions. Depending on what your count is, either 37 or 38 states have Blaine amendments that say some form of the words, no public funds for the aid, support, or benefit of sectarian schools. A number of Western states were required to adopt this language as a condition of admission into the Union. Well, fast forward a century later, and the modern school choice movement is starting, and the question of the constitutionality of vouchers, including religious schools, comes before the courts. there were two species, and of course I was very deeply involved in the litigation effort to defend these programs during my career at IJ and subsequently at the Goldwater Institute. But there were two primary focuses of the opponents of school choice. The first was the Establishment Clause in the US Constitution, and the second was an entire bevy of challenges that were made under various provisions of state constitutions, primary among them, the Blaine Amendments. And ultimately, we prevailed in year 12 of the modern voucher movement in 2002 on the Establishment Clause issue in a case called Zellman versus Simmons-Harris by the resounding vote of 5-4. And in that case, the US Supreme Court upheld school vouchers in Cleveland, and they did so based on two principles: that these programs were based on true private choice, that is, no dollars cross the threshold of a private school or a religious school unless they were directed there by parents. The other principle was neutrality, and that is that the state was being neutral as between religion and non-religion. So as time goes on, the opponents of school choice do not give up, but they shift the focus to state constitutional provisions. The Blaine Amendments are effective in a number of states in stopping school choice programs, though not in others. And they're also effective in the legislative arena, where a number of opponents of school choice say, you know, we'd really love to adopt this program, but we're forbidden by our very own state constitution. So this is a significant barrier to school choice that includes religious schools. So the Institute for Justice and other groups began devising legal strategies to actually tame the Blaine Amendments. And the idea that they seize upon is that these amendments are not neutral. They are, in fact, anti-religious and can be used to discriminate against religion. So a number of cases raise these arguments, raise these concerns. Justice Thomas, in a concurring opinion in one of these cases, talks about the bigoted history of the Blaine Amendments and that these amendments should be buried. So we come up in the year 2017 to the case where this issue seems to be squarely presented, a case called Trinity Lutheran out of Missouri. There, the state of Missouri had a program providing funds for repaving playground surfaces. Certainly not normally the stuff of US Supreme Court decisions, but nonetheless, this is the case that went up there. And a religious school applied for this grant and was denied solely on the basis of the state's Blaine Amendment, saying, you know, if you were a private non-sectarian school or a public school, you could have access to this grant. But if you're a religious school, you cannot. Goes up to the US Supreme Court. Everyone is thinking that the question of the Blaine Amendment as applied in a discriminatory manner is squarely before the court. And school choice opponents are jubilant when the court, by the very unexpected vote of 7-2, strikes down this discrimination in Missouri, except that 4 justices join a footnote. And this is one of the strangest footnotes I've ever seen in the history of American jurisprudence. 4 justices say, this case involves express discrimination based on religious identity with regard to playground resurfacing. We do not address religious uses of funding or other forms of discrimination. In other words, an entire Supreme Court decision focusing solely on playground resurfacing. Justice Kennedy, who was one of the justices who joined in that footnote, goes on, of course, to retire, replaced by Justice Kavanaugh, who is a very strong proponent of religious neutrality in the Establishment Clause context. And another case goes up to the US Supreme Court, Espinoza. This one does squarely involve a school choice program, specifically a tax credit for contributions to scholarship funds. The state of Missouri enacts this program to provide assistance, tax benefits for all schools, religious and non-religious. The Montana Supreme Court says, you know what, we have a Blaine Amendment. You can't include religious schools, but we're going to make this neutral. We're going to strike down the law in its entirety. And so the Institute for Justice takes this case up to the US Supreme Court. It's a bit nerve-wracking because, in a sense, the Montana Supreme Court did achieve neutrality, but it did so by abolishing the program in its entirety. This time, on the last day of the normal term of the US Supreme Court, the Supreme Court, by, again, the decisive vote of 5-4, ends up striking down the application of the Blaine Amendment to discriminate against religious schools, basically saying that this is a discrimination based on the religious status of people, parents, and taxpayers who otherwise would have the opportunity to access this benefit. And so the court holds that this is an unconstitutional discrimination. There's a number of concurring and dissenting opinions. That my favorite concurring opinion is by Justice Alito. And Alito doesn't think that you should be able to use history to prove discriminatory intent in a law. But he lost out on that in a previous case, that argument. He was in the dissent on that. And so he says, what's good for the goose is good for the gander, and writes a magnificent concurring opinion, including the use of a cartoon, which I'm not sure I've ever seen in a US Supreme Court opinion before. And certainly Alito would have been the last justice I would expect to put a cartoon in one of his opinions. But it was from the time of the adoption of the Blaine Amendments, showing alligators, which are Catholic priests, basically devouring school children who are trying their best to get to public schools. So Alito absolutely devastates the history of the Blaine Amendment. 4 justices say that this is an outrageous decision, a departure from centuries of American jurisprudence. 2 quick points on the importance of the decision. It really is, even though it's a huge victory for advocates of school choice, it really is a narrow one. And the Supreme Court says a state need not subsidize private education, but once a state decides to do so, it cannot disqualify private schools, some private schools, solely because they are religious. So this is an anti-discrimination provision or holding. It does not strike down Blaine Amendments across the board. They remain on the books. If they are used in a discriminatory manner, they are highly suspect. And the other thing is, once again, a 5-4 decision. The entire idea of school choice has been extremely contentious in the US Supreme Court. And so whether the school choice supporters or opponents really have the momentum at this point, it's really hard to say. It really will depend in future cases on the composition of the US Supreme Court and the fidelity of justices to the principle of stare decisis.
Excellent. Thank you so much, Justice Bullock. With that, we will turn to questions. I would like to remind our viewers to please submit questions either in the comments section of Zoom or via social media. With that, I will actually, I guess I'll exercise moderator's privilege. And I've got one for Professor Wilson, whose comment about the administrative state creeping into the culture wars I found alarming. I guess my question, in particular, are these manifestations of the administrative state getting into these culture wars, do they tend to reflect amorphous, capacious, imprecise, ambiguous delegations from Congress? I mean, I'm confused about, I operate in the realm of economic regulation. So I'm just confused on what sort of authorities agencies are exercising in order to get into the culture war? And if you could answer that, and also potentially, what do we do about it? I mean, that seems problematic to me from a number of angles, be it accountability or otherwise.
Yeah, so that's a great question, Will. You know, I think, look, a lot of this is the fact that the footprint of the administrative state, just how much it reaches into our lives, is greater and greater. I don't know that it had to go that way with the ACA. In other words, preventative care services might not have included contraceptives whatsoever. But, you know, there'll be people who come into some administrations with particular values. So if your valence around this issue is pro-woman, you know, you could see why a scientific body would just go, okay, let's grab every FDA approved drug and put it on the list, without a thought for the idea that there was a longer history around religious and moral objections, right? And without a thought for the fact that the only reason the ACA was even enacted was because some pro-life Democrats negotiated an executive order from President Obama saying that this would not be disrupted, and you know, concessions specifically in the statute. So in some sense, you know, you see people within the, you know, the agencies, I think, maybe trying to carry out, you know, what they see as the mandate, but without a wider lens to the longer history around abortion. So I think they just missed it. And then, you know, as I said, you know, many people will hear this idea of trying to balance the rights of women and religious objectors as somehow authorizing abortion. That's not my position. But you can see that what the Trump administration tried to do to undo that first harm was actually sort of referring us back to a longer history and kind of calm place that we've had around abortion. So I think to some extent, it's like a nuclear arms race. Once one team gets out with something, you're going to see the other guy do that, and you're just going to see it continually going back and forth. Aaron Nilsson has written an interesting piece. He's a professor at BYU about sticky regulation. But basically, in the article that I've done, I said, you know, we may want to think about whether there should be a standing down from this tit for tat process. Otherwise, we're going to have whiplash from administration to administration.
You're here. That an escalating arms race. Well, not comforting. For Professor Whittington, and the question is, under the reasoning of either the Kagan or Thomas opinions, could a state fine its U.S. senators for voting a certain way in the Senate, or can the reasoning of this case be cabined to apply only to presidential electors?
So I think particularly under the Thomas concurrence, you can imagine space for states potentially to fine senators for voting in particular ways, since Thomas regards this as part of the reserve power and doesn't rely upon any particular text of the U.S. Constitution itself. It's not clear that there's a good grounding in the text of the Constitution that would preclude the idea that under the reserve powers of the states, they could impose those kind of sanctions under Thomas's theory. Under Kagan's theory, I think it's a little trickier. Kagan relies heavily on the text of the Constitution that specifies the manner in which presidential electors are appointed and attaching conditions to the manner of their appointment. That under the 1787 version of the appointment of U.S. senators, you can imagine very easily being extended to U.S. senators. Now with an amended version where senators are popularly elected, I think it's much trickier to imagine that's the case. And so I think it'd be relatively easy for the court under Kagan's logic to want to distinguish between senators and presidential electors in particular. And it's one virtue potentially of having that sort of specific textual hook that Kagan wants to rely on that doesn't open the door to quite the expansiveness of state action that the Thomas concurrence potentially does.
Thanks. Excellent. Our next question, I believe, is for Justice Bullock. It is from my colleague Ilya Shapiro. and I'll read it verbatim. I've been saying that Espinoza is the last legal obstacle to school choice programs. Am I right? I believe you're on mute.
Sorry, I thought I had unmuted. In my experience, Ilya Shapiro is never wrong, so I need to find a different word to describe the statement that he made there. The answer is that there are other obstacles to school choice programs. For example, at least 2 states, Florida and Colorado, have struck down programs under different provisions of their state constitutions. In Florida, it was the Uniformity Clause, which guarantees a uniform public education, and the Florida Supreme Court ruled that anything that really was a different form of education from the public system was unconstitutional. I don't know whether that decision has continuing vitality, but it did lead to the invalidation of the voucher program there. And in Colorado, there was a local school voucher program in Douglas County that was struck down under a provision that only 6 states have that requires, that forbids this type of local program. And the thing about these provisions, unlike the Blaine Amendment, which lent itself to a case going up to the US Supreme Court because there was the federal constitutional issue of whether these programs were permissible under the Free Exercise Clause, those kinds of decisions based on state constitutional provisions that are not themselves problematic under the US Constitution, they can't be appealed to the US Supreme Court. So in those instances, you have constitutional obstacles that are not reviewable by the US Supreme Court. My former nemesis, Robert Channon, who was the general counsel of the National Education Association, and we argued these cases against each other so frequently that I could not only recite his argument, I could do it in his voice. He called this his bag of tricks. He said constitutional provisions and state constitutions are replete with opportunities to challenge school choice programs and even charter programs for that matter. And I have to say he was absolutely right.
Excellent. Thank you very much. As follows. Does the argument that winner take all rules are unconstitutional have any traction given Judge Wynn's dissent in South Carolina in the South Carolina case that went to the Fourth Circuit? Did that come through? It alerted me that my internet was a bit unstable there. Did you hear that, Keith?
No, I missed part of it.
You missed. All right, I will repeat the question. I'm sorry about that. All right. It was, again, from Robert Fitzpatrick. It was, does the argument that winner takes all rules are unconstitutional have any traction given Judge Wynn's dissent in the South Carolina case that went to the Fourth Circuit?
Right. That really turns on a different kind of constitutional argument than what the U.S. Supreme Court was looking at in the faithless electors case. It turns on claims about how the voting rights cases under the Equal Protections Clause play out in the specific context of the Electoral College. So I don't think there's going to be any direct effect between what the court did with faithless electors and the implications for thinking about the winner take all rules relative to the 14th Amendment, at least. I would not be surprised if we don't see more litigation making this kind of argument, though, about potential implication of the Equal Protection Clause for how the Electoral College is structured, and particularly this choice by the states. You can't imagine that the 14th Amendment makes the Electoral College per se unconstitutional, but states have chosen how to delegate presidential electors and how to allocate them out to candidates, and most states have chosen to allocate them as a single unit. They've done this from very early in American history because it gives states more weight in the process as they allocate all of their presidential electors to a single winning candidate. But modern equal protection jurisprudence, as it applies to voting rights context, I think does raise some genuine questions. So far, courts haven't bought into that. But the argument that was played out in the dissent in that circuit court case, I expect to hear played out in other cases in the future.
Excellent. Thank you very much. Our next question is for Professor Wilson. This question is from Feminists for Liberty, and it is, what can we do to free debates about reproductive health from the culture war and allow people to make their own individual choices?
Well, that would require that the government don't go around paying for so much stuff, because, you know, when you're paying with your own money, that's a whole thing. So that's one piece. But let's just take the world where we find it, where it does, right? It pays for Medicaid, it pays for, you know, Medicare for older folks and certain categorically eligible people, pays for all kinds of stuff. In that world, I think we need to be grooving to where Obama was. We need to be trying to vindicate competing rights. This wasn't that complicated. We didn't have to put 4 drugs on the list that by their own labels said that they acted in a way that would be seen as abortifacient by religious objectors, when we have had a detente around this since 1973 in Roe v. Wade. What we could have done, and what a number of prominent religious liberty advocates urged the Obama administration to do, people who were on the Obama administration's own faith council, was to say that they should do an expansion of Title X. I mean, let's be honest about this too, and I appreciate the real feminist perspective. Lots of women need to be able to control their reproduction. Okay, it affects their life chances. If they have a child, for example, they're already struggling to keep well, and then they're pregnant with another, this is a problem, right? If they're raped, this is a problem. If you know, they want simply to control the size of their family, this is a problem. So I think we need to think really hard about the humanity of these questions and try to find ways where we can recognize needs that people honestly have, but not ask people who cannot simply do that thing to do it. We've had a live and let live around abortion for a long time. It served us well. What we should have done was expanded Title X. But you know, what I hear from inside of the Obama administration is they thought that would just light off a culture war. And ironically, the way they went around it a different way lit off a bigger one, I think.
Thank you. Yeah, wonderful. I think we've got time for one more question. This one is directed to Justice Bolick. It is from Roy Miller. And the question is, how significant is the court's apparent reluctance to expressly overrule the Blaine amendments?
Well, Roy, you could have just called me up and asked me this question, but no, seriously. I don't think that question really was before the Supreme Court to actually say, Blaine, you can't have a Blaine amendment. And so the court was naturally reluctant to go that far. But really, when you think about it, the only time a Blaine amendment is going to present constitutional difficulties is when it is used to thwart a religious choice. And so I think that if the Blaine amendment is a fanged creature, the fangs have been removed from the Blaine amendments, and I don't know what continuing vitality they have in other contexts, but the court did not erase them, and I think that the court perceived that it really did not need to erase them.
Let's see, we've got 5 minutes left. That might be enough time for one last question. Actually, again, to you, Justice Bolick, and if you could please keep the answer short in light of our 5 minutes remaining. Why, and this is from Nicholas Little. Why is the alleged anti-Catholicism of no aid clauses relevant to a case regarding a state constitution adopted in 1972? Was Montana religiously discriminatory in 1972? Do we presume bigotry on the part of the Constitutional Convention?
So I'm so glad that that question was asked live. I don't think the majority hitched the unconstitutional, oh my gosh, why can't I say one of my favorite words? Unconstitutionality of the Blaine Amendment to the bigoted history. If it did, it would be difficult. For example, my own court in a case that I argued before it said that its amendment is not a Blaine Amendment and doesn't have bigoted history. So then Espinoza wouldn't apply to the Arizona Constitution. So it really is grounded in the notion of neutrality. The court mentions it. It mentions in passing that basically the 72 legislature readopted what had a bigoted history, but it really was Justice Alito who went after it in a big way. And frankly, I think he did that not so much that he felt that it was central, quite the contrary. He says it shouldn't be central to the constitutional question, but really to hoist his colleagues on their own petard. He really loves to do that. I think that he has succeeded Scalia as probably the greatest dissenter on the court right now, certainly the most sarcastic one. And in this instance, he did not have to dissent in order to get some serious snarkiness out.
Excellent, excellent response. Well, I think we'll wrap it up at that point. We've only got 3 minutes remaining. I would like to thank our panelists. That was great. That was a wonderful presentation by everybody and a great Q&A. And for our viewers, I think it's a 15-minute break before our next panel. And with that, we'll conclude this one. Thank you.
Thank you very much.
Welcome back, everybody. This is our final panel of the day, which has gone, and we never done a virtual online Constitution Day before, so I think it's going better than I thought it would. And it's actually going excellent. So this one I expect, as is always, is the sort of more laid back, informal, looking ahead panel, where we're looking ahead to the court's term that begins in a couple weeks. Joining me for the panel, we have Anastasia Bowden, who's a senior attorney at the Pacific Legal Foundation and a former Cato legal associate. That's along with Nick Mosvik on the second panel, is the second former Cato legal associate joining us today. At PLF, she challenges anti-competitive licensing laws and laws that restrict freedom of speech. She is the co-host of the forthcoming Supreme Court podcast, Dist, with Elizabeth Slattery, formerly of Heritage, now of Pacific Legal Foundation, and also Elizabeth contributed last year's Looking Ahead article, and Anastasia did this year's Looking Ahead article. Also joining us is Tom Goldstein, partner at Goldstein & Russell. He has served as counsel in party to roughly 125 merits cases at the court. This fall, he will argue his 44th, Google v. Oracle, on behalf of Google, which has been described as the copyright case of the century. I'm sure Tom has been thinking a lot about copyright recently, so we can maybe talk about other things. Only 3 lawyers in the court's modern history have argued more cases in private practice. Tom is also the co-founder and publisher of SCOTUS Blog, something I'm sure you have all heard of, a website devoted to comprehensive coverage of the court, which is the only weblog to ever receive the Peabody Award. And finally, Kim Robinson, who is the Supreme Court reporter for Bloomberg. Welcome, everybody. We're going to start with Anastasia, kicking it off with a few discussions, and then we'll go down the line and then open it up to questions later. Remember, we would love for you to ask questions. You can do that on social media. You can do that via the Q&A here on Zoom, and the Twitter hashtag is hashtag Cato SCOTUS. Anastasia?
Thanks, Trevor, and thanks to you and Ilya and Cato for having me. It's every constitutional lawyer's dream to speak here on Constitution Day, or at least it was my dream when I was an intern, as you said just a decade ago. In writing my article for the Cato Journal, which is, of course, the looking forward article, and talking about the upcoming Supreme Court term, I observed that this year looking forward in many ways means looking back. And one reason is simply the holdover cases. There was a series of cases that was originally scheduled for argument last term, but after the court closed for a short period due to COVID, these cases were rescheduled for this term. And so for many of us, we're looking back to cases that we were expecting to hear last term. This includes the Ford Motor case regarding personal jurisdiction, the Tanzing case regarding money damages under RFRA, and Carney, which Kimberly's going to speak to, regarding the political affiliation of state court judges. Another reason that looking forward now entails looking back is that the court is considering issues that are extremely similar to those that it considered last term. So in the Collins case, it will decide the same question it decided last year in Seila Law, that is whether a limitation on the president's removal power violates the separation of powers, but it will consider that same question in the context of a different agency. In the Facebook case, the court is once again going to consider the reach of the federal robocaller ban. That's a law I didn't know existed because I get robocalls all the time. I didn't know that until last term. And last term, the court had considered the very same statute in the Bar versus American Association of Political Consultants case, and it's going to do so again in the Facebook case this term. And lastly, in the Edwards case, it will decide whether its decision last term in Ramos, which extended the Sixth Amendment guarantee of a unanimous jury verdict to the states, applies retroactively. But to me, the biggest sense of deja vu comes from the fact that the court is slated to consider whether the Affordable Care Act, aka Obamacare, and its individual mandate are unconstitutional. I was an intern at Cato when this case was first being heard, so it's truly deja vu to be here again talking about it, except under drastically improved circumstances on the stage rather than editing the journal. This is the 7th time that Obamacare is being heard before the court. The court has considered the Medicaid expansion, the employer contraception mandate under RFRA, the application of that contraception mandate to religious organizations, whether an administrative agency has authority to exempt religious organizations from that requirement, tax credits as applied to federal exchanges, reimbursement requirements for the government to reimburse insurers who sustain losses as a result of the ACA. So there have been many cases, but the most famous case was that initial challenge in my mind, NFIB versus Sebelius, which challenged the requirement that individuals purchase health insurance or pay a penalty. That's the so-called individual mandate. In NFIB, Chief Justice Roberts famously used a savings construction to uphold the law as a tax. He said in his opinion that this was not the most natural interpretation, but it was a fairly possible one. Chief Justice Roberts did, however, agree with 4 dissenting members, Justices Kennedy, Scalia, Alito, and Thomas, that the mandate exceeded Congress's authority under the Commerce Clause. So the mandate stayed on the books, but we did have that holding, at least with regards to the extent of Congress's Commerce Clause power. Well, in 2017, things changed. The administration had changed, Congress had changed, and Congress reduced the tax for not having health insurance to nothing. That is, to the lesser of, I think, 0% of one's income or $0. And so naturally, there was another lawsuit. 2 individuals in 18 states filed a new lawsuit arguing that the tax was no longer a tax because it doesn't raise any revenue, and raising revenue is the very definition of a tax. The tax is gone, the tax is now a mandate, and under that original decision in NFIB, it is an unconstitutional mandate, and furthermore, it cannot be severed from the rest of the act, so the whole thing must fall. Now, some people have said to me that they think that this is too clever by half, but indeed, it has won the day. At the district court, the federal defendants themselves agreed that the law was unconstitutional, even if they disagreed on the severability point. And based on the fact that they agreed on the merits that the law was unconstitutional, a group of states intervened to help defend the law on the merits. And that's how we get the case name California versus Texas. Texas was initially one of the states that brought suit, and California was one of the states that intervened to help defend the law. The district court agreed with the plaintiffs that the law was unconstitutional, and it struck down the entire act. Granted, it stayed its judgment pending appeal. And the Fifth Circuit affirmed, except for it remanded on the severability point. And now the case has been petitioned to the Supreme Court, and the Supreme Court gets to decide once again, and particularly Chief Justice Roberts gets to decide once again, is this mandate/tax, not tax, constitutional? I think there's a lot of ways Chief Justice Roberts and the court can get out of ruling on this. They could get derailed by the standing argument. There is a standing argument that the plaintiffs don't have standing because this is just a choice. They don't have to abide by the mandate. There's no penalty for doing so. So they're not really harmed by the law being on the books. The same goes for the states. And there's also the severability question, which will allow the court, if it wants to strike down the mandate, but very narrowly and leave the rest of Obamacare intact. So that is Obamacare. The second case I want to speak to is Tanzin versus Tanvir. In this case, the court will consider whether the Religious Freedom Restoration Act, also known as RFRA, allows a claim for money damages where the plaintiff sues a federal official in their individual capacity. The case arose when a group of Muslim men, all of which were U.S. citizens or lawful permanent residents, alleged that a senior government official placed them on the no-fly list, in some cases 4 years, as retaliation for refusing to become FBI informants. At least one of the plaintiffs was banned from traveling by plane for several years despite presenting no known threat to aviation safety, causing him to lose his job, which required him to fly, and depriving him of the ability to visit his family in Pakistan. The men alleged that they had refused the officials' overtures to act as informants, at least in part because of their sincerely held religious beliefs, which triggers RFRA, and so they sued these government officials under RFRA. After giving the men the runaround for years, giving them pretty much no answer even about whether they were officially on the no-fly list and giving them no redress, the men had sued, and the government changed its tune. It changed the redress procedure, allowing them to once again petition through that procedure, which the men did. And the government responded that they didn't see any reason why the men should be on the no-fly list. They didn't have anything on their end. So now that these men had gotten redress, they dismissed those claims, but they wanted their claim for damages to move forward. And the district court dismissed that claim on the basis that RFRA does not permit money damages against government officials. The Second Circuit reversed. It held that it does permit money damages, and now SCOTUS has granted cert to hear it. And the dispute here is about when courts should be able to impose money damages as relief against government officials. RFRA itself is not explicit about money damages. The government argues that by deciding whether to impose money damages, the court is essentially making a policy decision that has policy implications. It can dissuade officials, says the government, from acting vigorously to perform their duties because now they're going to fear possible money damages. And the plaintiffs argue that courts should be presumed to have the inherent power to provide all appropriate relief, including money damages, unless the legislature says otherwise. And that actually preserves the separation of powers between courts and legislatures because it offers all forms of relief to the court, and the legislature can then later make a policy decision about whether to provide immunity or indemnity or what have you. But where there's no clear intent from the legislature to exclude money damages, we should presume that courts have that power, and that actually preserves the proper separation of powers. The reason this case is important is because money damages are often an important remedy for plaintiffs who seek to vindicate their constitutional rights in court. Where people have been injured and injunctive or declaratory relief is impractical or unavailable, damages often are the only way to make the person fully whole. And even when they're not the only remedy, they are an important means of imposing accountability. So that's a dispute that's going to be heard next term. The last case I want to talk about is Uzabanam versus Proshevsky, involving whether a claim for nominal damages defeats mootness. Sometimes when you sue the government, you may have the effect of inducing the government to change its policy at some point before the court issues its ruling. And that's generally a good thing. You get the policy changed, except that in the absence of a court opinion, the government may choose to resume its policy at a later date down the line. And so the plaintiff doesn't really get what they asked for, that is the prevention of the government ever doing this again, and they don't get the full vindication of their constitutional rights. Yes, the government has ceased the policy, but they've never got this vindication of their constitutional rights in court, which they feel is important. Nevertheless, when plaintiffs get something when they get what they asked for, primarily like getting rid of an unconstitutional policy, courts will generally rule that the case is moot and that they no longer have jurisdiction to hear the case. But that's not true necessarily when the plaintiff brings a claim for nominal damages. So the facts of this case are that Uzabunam was stopped by campus police from distributing religious literature at his college when he was a student. And when the officer stopped him, he explained that no one could distribute writings of any kind at that location, given the school's freedom of expression policy, which I think is sort of ironically titled. Instead, students were forced to distribute literature or speak in certain zones, which occupied a very small part of the campus and were open just 18 hours a week. So Uzabunam dutifully reserves a zone only to once again be approached by a member of campus police who says that there's been complaints about his speech and who asks him to stop speaking. And the officer informed Uzabunam that his speech qualified as disorderly conduct under the school's student code of conduct. After this second encounter, Uzabunam sued university officials under the First Amendment, asking for declaratory and injunctive relief and nominal damages. And of course, is not uncommon when the government knows it's going to lose. The college revised its policy to permit speech everywhere without a permit in limited circumstances and changed its code of conduct. And then it moved to dismiss the lawsuit as moot. Now, as a litigator that often sues the government, and I think I can speak for many plaintiffs here, this is very, very frustrating. Yes, you've gotten the policy change, but plaintiffs also want the court to vindicate their injury. They want the court to acknowledge that what the government did was unconstitutional. That is a primary role of the court, is to ensure this constitutional accountability. And oftentimes it takes years slogging through litigation up until the eve of trial to get the government to change its policy. And it seems deeply unfair that they can get off scot-free by just changing their policy, never acknowledging that they've done any wrong to you in the past when you have in fact been injured. The policy has injured you in the past. So the plaintiff's claim in this case is, I have a claim for nominal damages. Those nominal damages represent the vindication of my constitutional rights, and that's not nothing. I should be able to pursue that even if the government has dropped its policy. And of course, nominal damages are allowed. You would be entitled to that if you won on the merits, so you just want that claim to go forward. The district court granted the motion to dismiss based on mootness, ruling that since the college had changed its policies and there was no basis to expect that it would return to them in the future, the case was moot and nominal damages could not save the suit from being moot. The 11th Circuit affirmed, and this created a deep circuit split, or it deepened the circuit split between 6 circuits who hold that the government's policy change never moots nominal damages claims, the 2 circuits that hold that nominal damages claims will defeat mootness if the policy has in fact been enforced against the plaintiff in the past. And then the 11th Circuit, which held that such claims are always moot unless there is an accompanying compensatory damages claim. The plaintiffs again argue that nominal damages claims represent a constitutional injury and should be treated the same way that compensatory damages are treated. I thought it was really interesting, the diverse array of groups that filed amicus briefs in this case in support of certiorari, demonstrating the broad interest among organizations that litigate in the public interest. They clearly recognize that this is a problem. The amici included groups across the religious spectrum, the Foundation for Individual Rights and Education, that's FIRE, groups like Young Americans for Liberty, the American Humanist Society. They all recognize that you need to get your rights vindicated in court in order to have a just society. And I also thought I wanted to point to the Americans for Prosperity brief, which I thought wrote a particularly interesting amicus brief, arguing that the 11th Circuit's decision exacerbates the problems wrought by qualified immunity, because it noted that you can only overcome qualified immunity when there is well-established precedent on point. But when you allow mootness like this, you allow the government to evade well-established precedent. And, there's enough problems with qualified immunity doctrine itself that it sort of builds on itself with this mootness problem, where it makes it extremely difficult to ever point to precedent because it's so difficult to develop precedent in the first place. And in fact, if you read that brief, there is a citation to Judge Willett, who describes the qualified immunity conundrum and how it sort of builds on itself and makes it harder and harder to ever, in fact, impose immunity. So those are the 3 cases I wanted to speak to, and I'm happy to field questions and speak to the other panelists.
Thank you, Anastasia. Tom?
Sorry, I had to get unmuted. Well, thanks so much, Trevor and Anastasia. I thought that I would give a couple of thoughts about the cases that Anastasia was talking about, and then raise 3 other upcoming cases of my own. With respect to the Affordable Care Act, I do think the conventional wisdom is right, that it's extremely likely that the court will find the remainder of Obamacare severable. Last term, we had a couple of severability cases in which the court really did seem to signal that the right thing to do when you're confronting a provision of a statute that's unconstitutional is to try and save the rest. And that was true in Seila Law, the CFPB case, and another. And it doesn't seem like the court is trying to position itself in a way that would, so radically upend the American healthcare system. That's kind of the theme that I drew from the Chief's original opinion in the case, which is that the court itself shouldn't be making those kind of foundational decisions that have been the subject of debates in the country for decades and that are so important to people's lives. It wouldn't be at all surprising if the court followed through and held that the mandatory minimum coverage provision, which is the one that it was upheld as a tax, is now unconstitutional. But that's something that's an inconsequential ruling, given that everybody agrees that it's either unconstitutional or just defunct. Nothing happens if you violate it. But it's the remainder of the statute, things like the pre-existing condition provisions, that are super, super duper important, along with 900 other different things in the statute that affect the availability of healthcare in the country. I also was interested to see whether the court was going to hold argument in the case before the election under a true first in, first out system that the court generally follows. Certs granted, a case is slotted for oral argument. The court would have heard oral argument like a day before the election, but it has put the case back. The issues in the case obviously have enormous political valence. People care a lot about their health care. The administration has simultaneously said that it strongly supports pre-existing condition provisions and coverage. At the same time as the administration has filed in the Supreme Court, taking the view that almost the entire statute is unconstitutional, including the pre-existing condition provisions. So its public rhetoric and its litigation positions are hard to resolve and to align with each other. And it was interesting to see whether the court would be front and center in the election, right as we were going into the presidential election, but it looks like that won't be true. Nonetheless, it's obviously a critically important case. With respect to what we call voluntary cessation, the question of what do you do when you sue the government says, okay, we give up and we'll stop doing it. We had a very similar situation in litigating the legality and constitutionality of the acting attorney general under President Trump, where, for example, he had signed a regulation making bump stocks illegal. And we contended that he wasn't which are, they get attached to long guns and turn them into something closer to an automatic weapon, but not an automatic weapon. And we said that he had acted unlawfully because he was not the actual acting attorney general. He hadn't been lawfully designated as such. And the day before the oral argument in the DC Circuit, the Attorney General Barr ratified what it is that the acting attorney general had done. And so you see this a lot where the government comes along and tries to avoid the prospect of a court ruling. And it can be very, very, very troubling and very, very difficult for the courts to articulate what the law is. So it'll be very interesting to see whether the Supreme Court says that a request for $1 even though it's not $1 that'll make a difference to anybody, is enough to keep the case in court. There are a lot of competing considerations about that. The three cases that I wanted to talk about, one has been mentioned, is my Google case, and then a jurisdiction case, and then a computer crimes case. With the full disclosure that I represent Google, I'm going to just try and describe the case in ordinary and neutral terms. It's a complicated case. People have a very hard time following it if you're not in the field. It involves computer interfaces. You can think of an interface as kind of a door that connects two different computer programs. It allows information to be passed from one program to another. And for a long, long time, the computer software industry has understood that you could take a computer interface from an old program written by somebody else and reuse it in a new program. And that allows for new entrants to come in and offer better software, because if every new program has to have its own interface that's new and different from everything that came before it, it can be very, very, very hard for new programs to be accepted. And if they can reuse the interfaces from other programs, it's much easier. So you could imagine if there's an interface that allows, a photograph to be imported into Apple Photos. If a new photo company can come along and say, well, that computer program you've written to convert your thing into Apple Photos will work with our program too, the new entrant's much more likely to be accepted. Another example would be something like Amazon Web Services. If you are a cloud computing customer, the biggest player is Amazon Web Services. And so there's an interface that allows your files to be saved to Amazon Web Services. But if a new company comes along and offers cloud computing and says, all the stuff that you've written to work with Amazon Web Services will work with you can transfer your files to us as well, you're much, much more likely to be willing to think about using the competitor. In all events, that's how the software industry has understood things. The district court in this case found that that was true and that you can reuse interfaces. The case is brought by Oracle, and Oracle challenges Google's reuse of interfaces from a set of short programs that Oracle wrote for the Java programming language. And what happened was that when Google created the Android smartphone operating system, it reused these interfaces that allow Java software engineers, of which there are millions, to reuse the commands that they know from Java to write applications for Android, rather than having to learn thousands of new commands. The Federal Circuit, however, held that that was copyright infringement, that the interfaces are copyrightable and that the reuse of them is not fair use under the Copyright Act. The Supreme Court agreed to hear the case on the basis of its importance. The case went through the Federal Circuit, so there's no circuit conflict. And the Trump administration has joined Oracle's position, saying that you can't do this, you can't reuse these materials. They're supported by various content creators. On the other hand, Google is supported by the software industry and most of the nation's copyright scholars. So it's an interesting and important copyright case for the software industry and for the development of new technology. And whoever's right or wrong, I don't think anybody doubts the significance of it. The second cases that I was going to talk about are actually a pair of cases involving Ford Motor Company. They're about jurisdiction, that is the power of courts to decide cases, and in particular, they're about specific jurisdiction, which is the argument that you can file suit in a federal court because there's a particular link between the case itself and the jurisdiction, as opposed to the defendant more broadly. That's called general jurisdiction. So these specific jurisdiction cases are kind of law school hypotheticals that most people, I think, thought had been resolved by the Supreme Court, but it turns out not. And the case runs in a perfectly ordinary way, and that is that the plaintiffs buy a used Ford vehicle in a state. There's an accident, and they bring a claim alleging that the car was defective. To which Ford says, look, you can't sue me in the state where you bought the car and where the accident occurred, because I didn't sell it there. I sold it in 2 states over. The plaintiff says back, come on, everything about the accident happened here, and you sell 1 billion Ford vehicles into the state anyway, and so quit your griping. Well, the Supreme Court has been quite tough on jurisdiction in recent years, both with respect to general jurisdiction, the idea of whether you can sue a company for anything in a particular state, and specific jurisdiction, how close of a relationship there has to be between the events of the case and the defendant's activities in the particular state. And so it is very, very interesting to see whether the Supreme Court continues to narrow the jurisdiction of the courts. It has tended to do so in a way that has cut down on forum shopping, where plaintiffs are trying to get into particular courts, for example, the courts of the state of California. This isn't a forum shopping case in any way. The plaintiffs live in the state where they brought suit, and the accident happened there. It is instead a case that presents the kind of formalist question of, do you have to directly tie the defendant's activities in the state to the claim that is brought in the court, in the federal court in that state? The defense has been winning all the jurisdiction cases in front of the Supreme Court recently, and so it'll be interesting to see what they do in this case. The last case that I'm going to talk about is a case called Van Buren. It's a computer crimes case. The Supreme Court confronting more and more technology-related issues, as it is in Google versus Oracle. The case involves the unauthorized access of computer systems under the federal computer fraud statute. So you have here a cop, and a cop is asked to run a search on a law enforcement database as part of essentially an FBI sting. And he has access to the database in his job, requires him as a police officer to use the database, but he's using it for a reason that he's definitely not supposed to. And the question in front of the Supreme Court is that a federal crime, or is instead the federal criminal statute limited to circumstances that are closer to hacking, where you're not supposed to be using the computer system at all? And it's a difficult question. On an intuitive level, we don't want cops misusing law enforcement databases. That sounds to me like something that ought to be a federal crime. On the other hand, it's super hard to draw the lines here, because every employer has formalistic terms of service on how it is that you can use the company's computers, for example. So to Facebook. So there are innumerable restrictions on our use of computers that we are otherwise allowed to use. And it's very hard to know, if this criminal conviction stands, where the line is between, oh, you really shouldn't have done that, and hey, that's a felony, say goodbye to your family. It's not at all clear. The Supreme Court has very little experience with this, where it'll draw the line in terms of what an unauthorized use is. There's a very, very widespread support for the defendant in the case, alleging that this is a kind of limitless, boundless interpretation of the statute. On the other hand, privacy advocates are defending the application of the statute, concerned that people will misuse databases and other computer systems to which they otherwise have lawful access. So no doubt an important case for electronic privacy. So those are the three that I wanted to discuss. Kimberly?
Well, thank you, Tom. So I also have three cases. My cases are from the October sitting, the November sitting, and the December sitting, but that's probably the only thread tying them all together, is that they're well spaced out. So I'm going to kick off with Carney versus Adams, as Anastasia mentioned, and it's actually the case that's going to kick off the 2020 term on October 5th. So James Adams is the plaintiff here. He is a self-described Bernie Sanders independent, and he's challenging long-standing rules that effectively limit service on certain state courts in Delaware to individuals who identify as either Republican or Democrat. So states pick judges in many different ways, but the Delaware system is similar to the federal system in that the governor makes an appointment and the Senate confirms. One way that it's different from the federal system, though, is that Delaware has a law that basically requires that the bench be some people call it nonpartisan, but I think it more accurately requires it to be bipartisan. So made up more or less equally of both Democrats and Republicans. Of course, as an independent, James Adams is challenging this law, saying that he would like to be considered for one of these judgeships, but is ineligible to do so. So there are really two parts of this law that are at issue, the bare majority component and the political party component. The bare majority component just says that, no party can have more than just a bare majority on the court, and really requires that they be equal when they can be. And the political party component says the party who is not in the majority must be, or the part of the bench that's not in the majority must be filled by the other major political parties, that is Democrat or Republican. And the court added a standing question to the case when it took it. I'm not going to talk about that because it's boring, but I suspect the justices will talk about it since they asked the parties to do so. The issue really is about when government officials can consider an applicant's political allegiance for a job. And the Supreme Court has decided a few cases about that. Generally, consideration of political affiliation is prohibited, but there's a policy-making exception. And so very broadly, one of the factors that the courts will look at is whether or not the position is one that makes policy, whether there are discretionary duties, and whether they have decision-making for kind of major policies. And the purpose there is really to ensure that employees can't undercut the goals of the administration that is in power. And so we've seen courts uphold consideration of political loyalty for the director of a Veterans Administration Department, city solicitors, assistant district attorneys, and positions like that. The Third Circuit here said judges just simply don't fit that bill. It noted that they're actually required by ethics laws to be impartial and not loyal to one party or another, that they have to apply the law in a nonpartisan manner, and that they're even prohibited from engaging in partisan political activities. So the court acknowledged that, as Anastasia kind of mentioned, that of course, on some level, what courts do is make policy by deciding, for example, whether or not people can seek money damages for certain claims. But it said the question is really about whether or not that relates to the goals of the party in charge. And so the court used this example of a football coach of a public university. Of course, that coach makes policy for the athletic department, but it's not related to the goals of the current administration, although, of course, the line between football and politics seems to be blurring these days, but that's not up for consideration in the Supreme Court just yet. The Sixth and Seventh Circuits have gone the other way and said that judges can be policymaking bodies or positions, and that's probably the reason why the court took this case, was to sort out that circuit split. I think that the reason why so many people are watching this case and why I'm talking to you about it today is where it's happening. It's happening in Delaware. Delaware points out that its judiciary is, quote, the envy of the nation, and that its court system is really a major reason why corporations are largely chartered in Delaware. And of course, we see that Delaware has an outsized role in American corporate law. So that's Carney versus Adams. There's another issue about severability, but I'm not going to talk about that. Just to note, though, as mentioned before, that there have been a lot of discussion about severability, and so we'll see that again here. On to the November sitting, the court will hear Fulton versus City of Pennsylvania, which is not to be confused with City of Chicago versus Fulton, which has caused me an endless amount of confusion as I prepare for this term. The case out of Philadelphia is the latest in the fight over how to balance religious beliefs with anti-discrimination laws, particularly those relating to LGBT citizens. Now, the court has been grappling with that question ever since it recognized a right for same-sex couples to marry in Obergefell, but it hasn't really been able to come up with a satisfactory answer to that. And so, for example, we saw a couple of terms ago in Masterpiece Cake Shop that the court really found a really fact-specific way out of that case to send it back to the lower court. So what's going on in Fulton? This is another case out of the Third Circuit, and at issue is the City of Philadelphia's foster care program. The petition notes that there's an urgent lack of foster homes in the city, and that the agency here, Catholic Social Services, wants to provide homes, but is being prevented to by the city. Now, this is going to be I really wanted to get into the weeds of the facts of this case a little bit, but time does not permit that. But that's simply because I can definitely see a situation where the justices seize onto any number of facts to decide this case on a very narrow ground, rather than tackling, really the larger legal issue that businesses and local governments and individuals have been grappling with and asking for guidance for. So that big legal question centers around the court's controversial ruling in Employment Division versus Smith. And generally it said that, states can, but they don't have to provide religious exceptions to laws that are neutral toward religion or generally applicable. These gave rise to the federal RFRA and also mini RFRAs in the states, which really require a heightened need in order to be able to burden religious disputes. But that's not explicitly, Pennsylvania's RFRA isn't explicitly at issue here, although we'll see it as kind of playing in the background. So Catholic Social Services says that the city's application of its anti-discrimination laws, while it looks neutral, is not in fact neutral and is instead a pretext for discriminating against Catholic Social Services. And it relies heavily on Masterpiece Cake Shop, the case out of Colorado, where a baker refused to make a specialized wedding cake for a same-sex couple. And the Supreme Court found that the state agency that considered that case below was hostile towards the baker's religion. But here the Third Circuit said that wasn't the case. That's not what's going on here, that the city was really just trying to apply its anti-discrimination law. And, again, that's going to be a really fact-based question. But in addition to that question, the plaintiffs have outright just asked the court to overrule Smith. And I'll note that this is a time we've seen with the membership changing on the court recently. We've seen an increase of petitioners just asking the court to do away with precedent, and there's been a really robust conversation among the justices in their opinions dealing with this. So that'll be something interesting to see whether or not they tackle the factual issue or if they go straight for the precedent. And then finally, I'm going to talk about DOJ versus the House Judiciary Committee, which was just scheduled for the December sitting. So for this one, we're going to leave the Third Circuit and we're going to go to the DC Circuit and talk about perhaps one of the most DCest topics there is, the Mueller report. As part of Robert Mueller's investigation into Russian meddling into the 2016 election and possible obstruction of justice by the Trump administration, a grand jury issued more than 2,800 subpoenas and heard testimony from nearly 80 witnesses. Now, all of that material is subject to general grand jury secrecy laws, which prohibit jurors, court personnel, and government attorneys and others from disclosing what goes on in the grand jury. And Attorney General Barr said that required not only that he redact it from the public report, but also said that Congress members could not view the grand jury material. So Congress didn't like that very much. In particular, they wanted to see materials related to the Mueller investigation's obstruction of justice charge to try and show that there was a pattern by the administration. And they asked the DOJ to turn it over under an exception to the jury secrecy rules for, quote, judicial proceedings. So this exception allows for disclosure in judicial proceedings where there is a particularized need. And so the question here is whether or not an impeachment trial is a judicial proceeding that will allow the disclosure of that information. So in keeping with the long-time SCOTUS practice, that is probably the most boring way to talk about the Mueller report. And so that's the issue the Supreme Court is going to decide. The district court here found that the impeachment trials were judicial proceedings and required the DOJ to turn over some of that material. That's all been stayed while the case works its way through the courts. The DC Circuit looked at previous circuit precedent to agree with the district court, but it also analyzed the question for itself. It said the text of the Constitution talks about impeachment in ways that we think about the judiciary. So, for instance, it says whenever the president is tried, that the Chief Justice must preside. And the court also pointed to the fact that grand jury materials have long been provided to Congress in congressional impeachments, including the impeachment of 2 presidents and 3 judges, including President Nixon and Judge Nixon, which again provides me an endless amount of confusion in this area. Now, in doing so, the district court rejected the DOJ's argument that judicial proceedings only included those that took place in court, and it rejected the arguments on behalf of the administration that would actually cause separation of powers problems, not involving the executive, but between Congress and the courts, allowing courts to become unduly involved in the impeachment process. So I think one last thing that's important to note is that all 3 judges on the DC Circuit to decide this case agreed with the point about judicial proceedings, including Trump nominee Naomi Rao. And so that's how this case comes to the court.
Thank you very much, Kimberly. Again, I encourage everyone to ask questions in the Q&A here on Zoom, or you can put them into social media. I will take the moderator's privilege and throw a question out there. Well, for anyone, Anastasia brought up the standing issue in the Obamacare case, and I personally believe that they're like some of the conservatives want revenge on Obamacare, even if it's a nothing burger, as Tom pointed out. I mean, it's either doesn't do anything or it's unconstitutional, but either way, it doesn't do anything. But the standing issue is interesting, and I had done a little bit of research about whether or not people had been able to obtain standing in the past, just merely with a mandate without any penalties. And I don't know if anyone, Tom or Anastasia, looked into this. I know it came up in our original 2012 Obamacare stuff, where some people that I would debate on the issue, said that if the tax didn't exist, you would still feel a compulsion to. So it came up in the context of being like, if it wasn't a tax, the mandate, it would still be unconstitutional under the Commerce Clause, because you have a legal compulsion. Even without a penalty, that's still a legal compulsion. But it's an interesting argument. I don't know if anyone has further thoughts on that.
One
No,
thought.
sorry.
Go ahead.
No, go ahead.
Okay. Well, one thought I have is that in this case, even if the justices want to get out of hearing this case by using the standing issue, it doesn't seem like a case where technically it actually is a nothing burger, because here the plaintiffs allege, and the Fifth Circuit acknowledged that these plaintiffs said that they would follow the law merely because it's the law. And in so doing, they suffered an injury. They paid for health insurance they wouldn't have otherwise paid for. So at least in this case, I think it's very plausible that the plaintiffs did, in fact, suffer an injury. But secondly, I think there's just a rule of law consideration here, that it's not good policy to have all of these laws on the books that the government contends are not enforceable or don't mean anything or don't actually have any effect on you. I think that's a real problem. I think we should favor allowing people to go into court and to get them off of the books for the sake of our judicial system. But my last point would be that in practice, I am consistently confronted by the government saying that there is not standing for some technical reason, that, oh, the law isn't operating against you in a sure enough manner, or we can't be sure that it's going to turn out that way, or, well, you're not penalized, somebody else is penalized. And it's so, for example, in this Ninth Circuit case I have that's challenging the woman quota for the boards of publicly traded companies, the shareholders vote for the board members, and we brought a lawsuit on behalf of a board member and said he doesn't want to have to discriminate on the basis of sex. And the government said, well, he's not penalized for it. The corporation is. He can do whatever he wants. Sure, there's a law on the books that legally requires him to discriminate on the basis of sex, but because the penalty doesn't apply to him, he doesn't have standing. And I think that's a very unfair way of going about it. It ignores that the whole point of the law is to get shareholders to do something. The whole point of having the mandate on the books is because the government assumes that it's going to at least coerce some people into abiding by it. If they didn't care about having it on the books, why are they fighting back so hard? It's because we know that this has a coercive effect on people, that it has a deterrent effect. And so at least I personally favor allowing standing in these types of situations.
Yeah, I would be surprised if the court held that there wasn't standing. I mean, there is a doctrine that says there are certain legal rights that can't be vindicated in court, but this doesn't have the shape and feel of those. This is a real challenge to a really important provision of an incredibly important statute. And so the idea that, hey, nobody can bring suit because there's no enforcement mechanism seems very unlikely to carry the day that it stays on the books, particularly because of the real standing issues that certainly exist with respect to the follow-on arguments about severability. The rest of the statute has huge effects. So while there are some true formalists on standing in the Supreme Court, I would be very, very surprised if they could get to 5. I think Anastasia frames it correctly when she says like they could avoid deciding the case if that's truly necessary. But given that there's nobody thinks that the minimum coverage provision is supposed to actually have any concrete effect now, that there should be 9 votes for that, no matter what the theory. And given that there seems to be so much support in the court's doctrine and in common sense that the statute is severable. I mean, witness the fact that Congress withdrew the tax provision but left the rest of the statute standing. It seems one piece of evidence that they intended to withdraw the penalty and leave the rest of the statute standing. Given that the case seems almost relatively easy, I would be surprised if they went searching for off-ramps here.
It's interesting that at the time of the Obamacare case and the surprising tax penalty or decision, that you had a lot of people had pointed out, including myself, that this unicorn tax had to exist in between 2 precarious things. One is that if it got so high, it would be considered like a penalizing tax, and it could be problematic in that way. And one, if it got so low that it was no longer even a tax, so it had to be like right in the middle, the Goldilocks tax in that way. Kimberly, do you have anything to add on that, or no? I had a follow-up for Tom, and then again, please ask us questions if you have any. You kind of mentioned it a little bit, and I know a little bit about the Google and Oracle case, but there's so much interest in it from the tech community. What are, you're advocating for Google, of course, but what are the realistic implications to, like, what will we see things manifestly change with the phones in our pocket? Like, will the price of all these things go up drastically? Software, if they have to rewrite these interface codes every single time, for example.
I mean, that's certainly the perspective of our side of the case, that there's massive retrospective liability. Oracle's damage request in this case for Android, would probably somewhere be in the order of around $10 billion in this one case. And I think it's pretty indisputable that a lot of software has been written using the practice of re-implementing interfaces in this way. I think that the content community's view is, people adapt and people will create their own interfaces, and people have the right to the protection of the copyright laws. The copyright laws cover computer software explicitly. And the way to kind of encourage innovation is to make sure that these rights are enforceable. The overwhelming weight of the technology world is on Google's side of that question, but one ought not run past the point that kind of the point of the copyright laws is to ensure that content gets protection. And so it's not that Oracle's argument to the contrary is without force, and Oracle claims that these concerns are really pretty overstated because you can create new interfaces, and that this is effectively just a shortcut. So, but I do think that it is that concern that you're raising that ultimately caused the Supreme Court to hear the case in the first place. That the technology world had come to the Supreme Court and said, look, this is really going to be a huge problem if you don't put a stop to it.
I like this question that came from anonymous attendee to Anastasia. It's not exactly looking ahead, but she brought the case up. Where does the Constitution give the government the power to regulate who companies can choose to hire in your Ninth Circuit case?
Yeah, well, maybe that's looking ahead. I mean, I certainly hope it's looking ahead, because I hope in a future Supreme Court term, this case goes up to the Supreme Court and we get to the issue of whether quotas can come back. This is the return of quotas right now in this day and age. This law that we're challenging right now is a gender quota, but actually California just passed a racial and underrepresented minority quota as well. And so I think maybe it will go to the court one day. But in any event, I guess the state would say that it's utilizing its police power. It's power that's reserved to the states, just like it does to enact any anti-discrimination law. The funny thing about this anti-discrimination law is that it actually requires discrimination, because it requires people to take into account race or sex when they're making hiring decisions. And, so I think that's an odd way to go about anti-discrimination. And in fact, actually, when we've gotten into it, the government has not actually ever said that it's meant, at least in the context of the woman quota, to remedy discrimination. It said that it's actually just getting into the business of balancing, that it thinks that there should be balance for the sake of balance, which I don't think is a legitimate government interest. I don't think the government has any interest or authority to impose a law like that under the Constitution. It's antithetical to the Constitution. But the state would argue that it's part of its police powers.
David Frost asked the question, which we have with the, you can say it, Anastasia, I can't say the Uzabunum, is that how you say it? The name, yes, or something like that, sorry. It's close enough, but on the question of nominal damages and standing, this was interesting as David Frost asked about the New York Rifle and Pistol Association case, which tried to use, or tried to, that came up that maybe if they would have just asked for damages, this entire thing would not have come up. And that kind of brings up something I was thinking in terms of looking up ahead and maybe during the cert stage, cert petitions going to the court for next term. Did the court signal in the Second Amendment case, in not taking any of the 10 Second Amendment petitions and not taking any of the 10 qualified immunity petitions, that essentially you shouldn't try on this for at least for the near term? I don't know. I think Kimberly, you've written about qualified immunity a little bit, but if someone wants to field that.
Well, you know, there are other qualified immunity cases that the court's going to be considering in its long conference, as well as at least one Second Amendment case. So I think regardless of how people read the tea leaves of that decision last term, I think people are still going to keep trying. And I wonder if it was just more of a matter of timing, given that we are coming on election season. I know that we are in election year, but of course that will have passed by November. And I just wonder if the court is more willing to take those kind of controversial issues, you know, after the election rather than right before it.
Tom, you have any opinion on that?
Yeah, I mean, I am in the camp of the court having said functionally, we're not going to get into this right now. Joan Biskupik had a series of articles for CNN in which her reporting was that the court ended up declining the follow-on gun cases after the New York Rifle and Pistol case because there was a concern among Second Amendment advocates in the court that the Chief Justice was just not there and that they couldn't really have confidence in how those cases would come out. So this is an area, you know, where judicial conservatives, I think, continue to believe that the court's composition presents an obstacle to, you know, some of the more significant issues that remain open under the Constitution. With respect to qualified immunity, I mean, the court moves in general, much more slowly than society. There was extensive Reuters reporting on qualified immunity that has really drawn a lot of attention to the issue, along with all of the protests relating to police conduct and misconduct. And then there have been a couple of judicial opinions. So there is a lot of attention in the community to qualified immunity, but there isn't a lot of expression of frustration with the doctrine inside the Supreme Court itself. And so I don't see the court kind of reacting particularly quickly to narrow qualified immunity doctrine. And so long as it's not going to narrow it, there's very little incentive to take any of those court cases, because those who are concerned about qualified immunity think it's, you know, kind of run rampant. Those justices will think that the defendants are likely to win in the Supreme Court. And so I think that those cases probably got denied 9-0. You know, I think it's much more likely that there'll be a legislative fix with respect to qualified immunity, which after all is just a made up doctrine, than it is that the Supreme Court in the next, you know, 3 to 5 years will do anything. The Second Amendment is inevitable. I mean, the court cannot just leave this entire body of law out there with the resulting significant disagreements in the lower courts, some courts taking the Second Amendment seriously and some not. And having said there is this right, but we just won't tell you what it means, that's going to become untenable at some point. But, you know, we are just not at that point yet as far as the court's concerned.
I I agreed with you on the position, and I think that some of the unrest and political schisms of this year, for example, has John Roberts, which I think, in my opinion, and I think a lot of people's opinion, one of his main drives is maintaining the integrity and respect of the court from both sides. And he would not want to preside in this schismatic world. He would not want to preside over the court that loses all respectability because 50% of the country hates the other 50% of the country. And only in a Second Amendment case that was as mundane as the New York Rifle and Pistol Association might he be willing to weigh in for guidance. But I wouldn't expect much more on that. And seeing if we hear, I think we're just about out of time. We're going to change over, unless anyone had any final thoughts on any cases that are coming up or issues that are being watched in the cert world, or nope. All right. We're going to change over here just immediately after in the turnover. Oh wait, we did get a question. Oh, okay. In the turnover here, we're going to just stay here, and it's 4:30 comes in. We will have Ilya and Judge Don Willett come in, but join me in clapping in your own place for your panel. And thank you very much, everyone.
We'll get started. We'll leave a few more minutes for questions, which I'm sure you'll have for our distinguished guest. It's my distinct honor at the end of our annual conference to introduce the B. Kenneth Simon Lecture. Judge Don R. Willett was nominated to the U.S. the U.S. Court of Appeals for the Fifth Circuit on October 3rd, 2017, and confirmed by the Senate by the comfortable margin of 50 to 47 2 months later. Before that, he served on the Texas Supreme Court for over 12 years, having been appointed by Governor Rick Perry in August 2005. Before ascending to the bench, Judge Willett was Deputy Attorney General of Texas, serving under Greg Abbott, who later became governor himself. And before returning to Texas, Judge Willett was a Deputy Assistant Attorney General in the U.S. Justice Department's Office of Legal Policy, as well as serving in the White House as a Special Assistant to President George W. Bush and Director of Law and Policy for the Office of Faith-Based and Community Initiatives. Judge Willett's personal story makes his professional accomplishments all that more impressive. He was adopted by parents who hadn't finished high school, and his dad died when Don was 6. His mom waited tables to support the family. Don ended up graduating from Baylor University with a triple major, then from Duke University Law School with honors. It's perhaps this rags to riches story that caught the eye of Donald Trump's legal team, which put then Justice Willett on its list of potential Supreme Court candidates. Well, that or his lively and civic education-focused Twitter feed, which we all miss. Appropriately, Judge Willett will be speaking on flunking the founding, civil illiteracy, and the rule of law. And I'll just let everyone know that you can submit questions while he's speaking. If you're on one of our social media channels, it's hashtag Cato SCOTUS. If you're on Zoom, just submit it through the Q&A. And one more thing, we kind of had our wires crossed, but this bow tie that I'm wearing, this Constitution bow tie, used to belong to Judge Willett. And he has now the one that used to belong to me, which is this one, but in blue. Just one more item of trivia and showing how dedicated Judge Willett is to the Constitution and constitutional education. So, Don, please, the floor is yours.
Are we good to go, Ilya? Okay, thumbs up.
Ilya, thank you so much for that generous introduction. I've got to say, it was far kinder and gentler than one I received many years ago. I was speaking to a Rotary Club in Texas, and the treasurer introduced me, and he covered all the normal bases where I went to school and jobs I had held like you did. But then he made a jarring segue into how they really needed to raise the membership dues at the Rotary Club. And as he droned on, you could hear all these penny-pinching Rotarians start to moan and groan. And finally, the treasurer, he got really fed up at all the whining. He erupted and he bellowed, "Fine, guys, but mark my words. If we don't raise our dues, we'll never get any good speakers around here." Mr. Willett, thank you for coming. So that was a lot kinder. I appreciate that. You did manage to omit the most important thing. My Aunt Lynn, my mom's baby sister, used to hang out with Elvis. There we go. But I learned at a really young age, never ever ask Aunt Lynn about her time with the king, because, you know, she gets all shook up. So thanks for having me, or more accurately, streaming me from Austin, Texas. But even from afar, I'm really honored to find myself among those distinguished jurists and scholars who've delivered this lecture over the years. I grew up in a tiny town of 32 people. It was so small that, you know, our town square had only 3 sides. And the beauty of Zoom is you can't hear all the groaning, which is a thumbs up. But for a kid who grew up in a trailer surrounded by cotton and cattle, this opportunity is really high cotton for me. So thank you very much. 2020 has been a wild ride. And I say that as a former rodeo cowboy. So we were facing a confluence of overlapping crises: pandemic, recession, impeachment, social unrest. It seems that so far the most normal part of 2020 has been Tiger King. But we look for silver linings where we can, and the turmoil has perhaps sharpened our focus a bit on the 3 branches of government. So according to the 2020 just released Constitution Day Civic Survey, a whopping 51%, a majority of American adults, can now name all 3 branches of government, which is up sharply from 39% last year, which itself was an all-time high going back about 15. But, you know, truth be told, our nation still has a pretty abysmal civics IQ. We inhabit this age of miracles and wonders today, with access to mankind's accumulated knowledge at our fingertips. But it's also an age of really staggering civic illiteracy. And our civic temperature may be high in 2020, but our civic knowledge is not. And there's a lot to indict, but hopefully through commendable events like today's symposium, perhaps we can move from indicting to informing, and better still, inspiring and invigorating. So 233 years ago today, the Rolling Stones cut their first album. No, though they are a combined 306 years old. A throng of Philadelphians waited outside Independence Hall. And like most Philly crowds, it was tense. So our Constitution, our infant nation was floundering. The United States were anything but united. The Articles of Confederation had created this loose league of friendship, but the former colonies had yet to coalesce into a country. So for 4 sweltering months, delegates to the convention, they huddled in secret behind closed doors, and those on the outside were wary of those on the inside. And presiding, of course, was the venerated Virginian veteran, George Washington, the indispensable man. No Washington, no republic. But Benjamin Franklin, he was the nation's Renaissance man. His achievements in science and diplomacy and letters, they were unrivaled. Franklin was the embodiment of the American dream. So from penniless runaway to protean polymath, he was the most illustrious figure in early America. And he truly was, as one reporter called him, the incarnation of the true American character. So you all know the story. On the convention's final day, Franklin delivered the last great speech of his life, urging adoption of the new Constitution with all its faults, as Franklin said. And he found plenty of faults. He wanted federal judges, for example, to be elected. But Franklin, 81 years old, the oldest delegate, and at that point, the most renowned American in the world, he flexed his considerable diplomatic skills, and he implored his fellow delegates to doubt a little of his own infallibility, as he put it. He said, the older I grow, the more apt I am to doubt my own judgment and to pay more respect to the judgment of others. And I think we could all use a refreshing dose of that intellectual humility today. More humility, less superiority. Franklin was actually too frail to deliver that rousing speech himself. And a fellow Pennsylvanian, James Wilson, read it for him, but it was extraordinary and it worked. And there was unity, if not unanimity. And as James Madison scribbled in his notes, rather understatedly, if you ask me, the members then proceeded to sign the instrument. And we all know what happened next. Triumphant Franklin, he's approached by Mrs. Powell, who blurted out, well, doctor, what have we got, a republic or a monarchy? And Franklin delivered his famously sharp-witted rejoinder, a republic if you can keep it. So Franklin's zinger, it was heartening. A republic, no more monarch, no more royal absolutism. But it was also frightening, if you can keep it. It was ominous because it suggested that the survival of freedom depends on people and not on parchment. The duty of preserving our rich civic inheritance falls on us. We must ensure that our republic doesn't descend into anarchy or monarchy. And this is a job for everyday Americans like Mrs. Powell, who posed a question for the ages, the one that echoes even today. What have we got? This republic is ours to keep and ours to lose. But Franklin was not the first to recognize that the job to build this enduring nation is on us. 11 years earlier, on the same politically sacred spot, the Declaration, our original birth certificate, the greatest breakup letter of all time, proclaimed that we wanted government, as Lincoln put it 7 years later, of the people and by the people and for the people. This uniquely American theory of government was a radical experiment, the first time that a nation came into being asserting the inborn, individual, natural rights and equality of every human being. So listen to this word choice. We hold these truths to be self-evident. Governments derive their just powers from the consent of the governed. When government becomes destructive, it is the right of the people to change course. And when abuses and usurpations lead to despotism, it is their right, it is their duty to throw off such government to provide new guards for their future security. So pre-Constitution, the founders said the people wield supreme sovereignty over their government, to lay its foundation, to structure its powers, all according to what seems to them most likely to secure their safety and happiness. The power of the people is a truth that provides great comfort, but also grave discomfort. So fast forward to Constitution Day 2020, 23% of American adults still can't name a single branch of government. 19% can't name one right guaranteed by the First Amendment. 19% of adults under age 45 can pass a rudimentary 10-question multiple choice quiz about the founding. Many Americans don't know the how of our republic because they don't know the why of our republic. Margaret Thatcher, she once noted that Europe, unlike the United States, is the product of history and not of philosophy. America is sui generis, she said, because it was built upon an idea, the idea of liberty. And she was echoing Churchill, who called the Declaration a great title deed praising the love of liberty and justice on which the American nation was founded. Madison, of course, agreed. The European vision, he said, was charters of liberty granted by power, as opposed to this radical American vision, charters of power granted by liberty. So our founders, they were imperfect, but they were inspired, and they aimed for something transcendent, not to enshrine a mere process, democracy, but to enshrine a promise, liberty, and individual freedom, the essential condition of human flourishing. So our founders, they gambled big, and in my view, they hit the trifecta. They had hindsight, they knew the history of kings and dictators, so they insisted on a government of laws and not of men. They had insight, they knew that government exists to ensure the blessings of liberty, that liberty is not provided by government, but it pre-exists government, that liberty is our natural birthright, not a gift from the sovereign or from politicians. And they had foresight. They knew that to safeguard liberty, government must be structured to control its power. So knowing that a bunch of guys dumped tea into Boston Harbor doesn't mean a lot if we don't know why they dumped it. Which, of course, as the Beastie Boys taught us, was because you got to fight for your right to pour tea. And if we don't grasp the why of our design, it'll never command affection and reverence. Most Americans now say they don't trust any branch of government, not one. American national pride is at an all-time low. Only 51% of American high school and college students report being proud of America, and just 46% say they're patriotic. The father of the country would be dismayed. Washington made clear in his very first inaugural that this is on us. He said the preservation of the sacred fire of liberty and the destiny of the Republican model of government are staked on the experiment entrusted to the hands of the American people. And frankly, Washington himself was pessimistic. He confided to another delegate, quote, "I do not expect the Constitution to last for more than 20 years. Thankfully, he was wrong. Some nations, they number their years in millennia. America is approaching its semi-quincentennial, 250 years. And God willing, this nation has a long life left, but how can we reasonably be expectant about our future if we're ignorant about our past? And I believe it's a short trip from ignorance of our founding ideals to erasure of them." When he was 28 years old, young Abraham Lincoln spoke of this rich legacy bequeathed us, how we are the legal inheritors of these fundamental blessings. And he warned how danger would spring from within, from the increasing disregard for law, from what he called this mobocratic spirit. The founding generation had died, and Lincoln was worried about lawlessness. He was worried about the perpetuation of our institutions. And the antidote, he said, was the attachment of the people. And attachment includes a reverence for the Constitution and laws. But civic illiteracy, obliviousness to the what and the why of America, accelerates disattachment. Because if we don't know our history, warts and all, we can never understand our history. And we'll have nothing to hold on to, nothing to ground us. Just a few weeks ago, Ben Franklin, Mr. If You Can Keep It himself, who warned of the tendency of republics to implode, was himself targeted for cancellation, thus proving the wisdom of his insight. Franklin has gone from the first American, as one novelist described him, to a person of concern, according to a DC committee report. Franklin's name should be scrubbed from a historic landmark. and his statue should be, quote, removed, relocated, or contextualized. And it's not just him. George Washington, the man after whom the city itself is named, is also a person of concern. Thus, the Washington Monument, I guess all 81,000 tons of it, should be removed or relocated or recontextualized. And I guess notably, the DC panel made no recommendation on renaming the city itself. But I suspect that many of those we all saw on TV lassoing monuments want to topple more than statues. So amid today's pandemic, in my view, is something endemic, a deep misunderstanding of American self-government. Today's Constitution Day, but I think our confusion also runs to our true founding document, the Declaration of Independence. Jefferson called the Declaration an expression of the American mind. Lincoln called the promise of the Declaration an apple of gold, framed by the silver frame of the Constitution. Lincoln explained that the picture frame was made not to conceal or destroy the apple, but to adorn it, to preserve it. The picture was made for the apple, not the apple for the picture. The Constitution exists to serve the Declaration's promise of liberty to all. The Constitution provides the tools to build the government that secures the rights proclaimed in the Constitution, in the Declaration. The Declaration was high treason. It was a literal indictment of the crown in painstaking detail. It married disobedience with eloquence. Legend has it that one delegate who was afflicted with a palsy said as he signed it, "My hand trembles, but my heart does not." Every spring, there's a colonial day at my kid's school, and I put on this itchy costume, and I unroll this scroll, and I recite the Declaration of Independence, accompanied by these tiny fifth grade voices, and they've memorized most of it. And the first two paragraphs are vacuum packed. There was no beating around the bush. There was no hemming, no hawing, no throat clearing, no gauzy phrases like irreconcilable differences. The Declaration is declarative. So this was the Festivus of 1776, right? This was the airing of grievances. And the founders, they dialed it up to 11. So the second sentence is the most famous. We hold these truths to be self-evident. And this line does a lot of heavy lifting. It declares, number one, these rights belong to us as individuals. Number two, they are fixed, innate, our natural birthright. They are unrelinquishable, unwaivable, unsurrenderable. And number three, they're God-given, so they may not be taken away by man. So the next sentence is where Jefferson kind of drops the mic or the quill. The ultimate end of government is to secure these pre-existing inborn rights. Boom, Jefferson said. So as Professor Barnett famously puts it, first come rights and then comes government. The Declaration unveiled the American theory of government. And its bottom line is clear. Government exists to protect our individual, unalienable rights, rights that are ours by virtue of our very humanity. But as that founding generation passed away, so too did that unifying principle in the Declaration. So in 1838, long before he was president, Abraham Lincoln, he lamented this mobocratic spirit that was sweeping the country. He worried that wild and furious passions would destroy what he called the strongest bulwark of any government, the attachment of the people. Lincoln warned that when the people lose sight of that which binds us together, the ideal of liberty enshrined in the Constitution, in the Declaration, this government cannot last. And again, Lincoln was just 28 years old when he warned of America being torn asunder from within. And Fort Sumter was still 23 years away. So it is undeniable that at the founding, the ideals collided with the reality, America's original sin of slavery. 1/3 of the Declaration signers were slave owners. We were flawed and we were stained at the start. Jefferson's initial draft of the Declaration included an anti-slavery passage, but it was cut. America is imperfect, as all human things are. Even so, the Declaration's underlying ideals are timeless, and they are winning out. Lincoln would not abandon them even to avoid civil war. So at Independence Hall, just before he was inaugurated, Lincoln described equal liberty as a gift, not alone to the people of this country, but I hope to the world for all future time. The Declaration was a linchpin argument for abolitionists, and the Supreme Court in Dred Scott feebly tried to explain it away, unconvincingly. So my favorite piece of art in my chamber is an oil painting of Frederick Douglass. There's a picture of it. And in his iconic speech, "What to the Slave is the 4th of July," Douglass notes that the promises of liberty and equality in the Declaration are eternal, even if America broke those promises. So there was this jarring disconnect between the commendable words of the Declaration and the condemnable deeds of those who adopted it. But these founding ideals, they still lay the foundation for righting wrongs, including the new birth of freedom wrought by our second founding and the Civil War amendments that belong at the center of America's constitutional story. And this quest to live up to America's ideals is never ending. It requires constant striving. Even the aspirational 14th Amendment failed to fulfill its promise during its first 75 years. But the central idea of the Declaration, that all men are created equal, it set in motion this inexorable march. Dr. King, perhaps the most renowned protester in our nation's history, he called upon his fellow citizens not to tear down America's heritage, but to live up to it. After his own march on Washington, Dr. King demanded not that our founding documents be changed to fit new ideals, but that our government change to fit the enduring ideals of our founding documents, which he called a promissory note, to which every American was to fall heir. Perfection is elusive in this life, but bit by bit, amendment by amendment, we are drawing nearer to the first enumerated purpose of the preamble, formation of that more perfect union. So far, I've focused on the Declaration, our golden apple, which lies at the heart of the American project, but it is preserved through its silver frame, the Constitution. The Declaration is aspirational. The Constitution is architectural. The Declaration declared the purpose of government to secure our God-given rights, and the Constitution erected an ingenious structure to achieve that purpose. And it is imperative that we understand both documents so that, as Lincoln cautioned, neither picture or apple shall ever be blurred or bruised or broken. The framers, they were not tinkerers. They didn't pledge their lives and their fortunes and their sacred honors to fiddle around the edges. They upended things. Madisonian architecture infused with Newtonian genius, these three co-equal branches locked in synchronous orbit, held there by competing interest, ambition counteracting ambition, as Madison famously put it. It was a radical structure that divided power in order to control power. And the most extraordinary element, these three rival branches derive all their power from three unrivaled words, supersized on the page for all the world to see: we the people, not we the government, not we the judges, not we the subjects. This was an era of kings and sultans, and in that era, this was a script-flipping heresy. Nothing was more audacious, nothing more radical than the idea that sovereignty resides not in government, but in the governed. Popular sovereignty is a duty, it's not a mere theory. Shortly after the Constitution was signed, Jefferson wrote from Paris, "Wherever the people are well informed, they can be trusted with their own government." But how can we give informed say-so if we lack informed know-how? We, the people, are meant to be watchdogs and not lapdogs. And Franklin's warning, "if you can keep it," presumes, if you know it, that everyday Americans will be well informed and thus wield their sovereignty smartly. But again, we, the people's civic illiteracy is staggering. 71% of Americans cannot identify the Constitution as the supreme law of the land. 63% can't name one of their US senators. 62% can identify the governor of their state. 10% of college graduates think Judith Sheindlin, AKA Judge Judy, sits on the Supreme Court. Madison warned about this expressly. A popular government without popular information is but a prologue to a farce or a tragedy, or perhaps both. So get this, most of America's elite universities no longer require history majors to take a single course in American history. But there is a ray of hope. Naturalized Americans, those who have risked everything to help write the next chapter of the American story. When it comes to the US citizenship exam, immigrants, they get the job done. And do you know what percent of immigrants pass the civics test their first try? About 90%. And those same 100 multiple choice questions were given to some American high schoolers. And the passage rate, not quite as high, about 5%. So the generation with the greatest access to information is also the least informed. But an informed citizenry is indispensable to self-government. But even that is no guarantee of good government. Beyond education, you need engagement. And Franklin said, if you can keep it, because he knew the secret sauce was an engaged citizenry, American civic spiritedness. So here's how Tocqueville explained it. He said, the civic spiritedness of Americans is rooted in our three-dimensional sense of participation. Number one, we participate in creating our own and thus our nation's prosperity. Number two, we participate in the administration of local government, voluntary associations, what Edmund Burke called the little platoons of family and church and local community, all of which kind of incline us to civic virtue. And then finally, number three, through electing our representatives, we participate in the making of laws that advance our freedom and our prosperity. So American patriotism is anchored in that Tocquevillian vision of proactive citizens, sleeves rolled up, who take charge of their own economic and social and political happiness. American citizenship is not a spectator sport. And Justice Brandeis, I believe, put it well. He said, the only title in our democracy superior to that of president is the title of citizen. The Declaration and our Constitution are exquisite charters of freedom, but freedom requires patriots and not passers-by. They demand fierce defenders and not feeble bystanders. Take Lincoln. In 1858, he was by all accounts, a financially insecure, failing politician with no administrative experience. But the Supreme Court's Dred Scott decision, it galvanized Lincoln. And that June, he delivered his famous House Divided speech. It was poetic and it was prophetic. And while Lincoln lost that election, it was that legal analysis, his legal analysis of a judicial decision of all things, that catapulted him ultimately to Mount Rushmore. Lincoln was no mere bystander. His civic education, his civic participation informed voters who liked what they heard and who leveraged that knowledge into sending that failing politician to the White House 2 years later. And indeed, civic education, civic engagement can ripple across centuries. So let me tell you about a tenacious Texan with a Mensa level civics IQ. So in 1982, Gregory Watson was a 19-year-old sophomore at the University of Texas. And he wrote a research paper arguing that one of James Madison's proposed amendments to the Constitution was still eligible for ratification. And this dormant proposal, it would have barred Congress from giving itself a midterm pay raise. It was part of the original batch that eventually became the Bill of Rights. And the teaching assistant was thoroughly unconvinced, unimpressed, unpersuaded. She awarded Watson a big fat C. So Watson, fueled by fury and righteous indignation, he spent the next 10 years of his life lobbying state capitals from sea to shining sea until in 1992, the 27th Amendment was finally ratified, 203 years after it was first proposed. Gregory Watson got a bad grade, so he amended the Constitution almost single-handedly, and all it took was aptitude and attitude. And the cherry on top for Watson came 3 years ago, 2017, 25 years after ratification. He was brought up on stage and was informed that the university was changing his grade officially. And there's the official form, which states, in light of the student's heroic efforts to prove the professor wrong, Mr. Watson deserves A+. Last year, the federal judiciary convened its first ever National Civics Conference. Article 3 judges, including 3 Supreme Court justices, joined with law school deans, bar leaders, and others, all the way from Maine to Guam, to discuss how the judiciary could help boost civics literacy. A few weeks later, Chief Justice Roberts wrote in his year-end report that each generation has an obligation to pass on to the next not only a fully functioning government responsive to the needs of the people, but the tools to understand it and to improve it. And the Chief Justice was echoing Justice O'Connor, who commendably has devoted her post-court life to civics education. And as she puts it, knowledge about our government is not handed down through the gene pool. And she, in turn, was echoing President Reagan, who warned that freedom's never more than one generation away from extinction. We didn't pass it to our children in the bloodstream. And they're all right. This isn't something hardwired into our DNA as Americans. These habits of citizenship have to be taught and learned anew by each generation. And frankly, school children are often center stage when it comes to transforming our nation. So take Linda Brown, the schoolgirl at the center of Brown v. Board of Education. When the Supreme Court rejected racial segregation, it stressed the importance of education as a crucible for good citizenship. And honestly, for many students, schools may be the only place where they might be exposed to the American political tradition. But it won't be easy. A recent study examined the mission and vision statements of America's 100 largest school districts. And the study asked a simple question: what exactly is our purpose? I've always thought, I think the founders probably thought, that the chief purpose of education was to prepare the next generation for thoughtful and capable self-government. To know math, yes, but to also know how to take the measure of leaders. To know history, yes, but to also know what it means to be an American, to cherish our stunning political heritage and its vision of liberty and equality and justice for all, to help children be not just college ready or career ready, but civic ready. As Jefferson put it, if a nation expects to be ignorant and free, it expects what never was and never will be. Education, he said, enables every man to judge for himself what will secure or endanger his freedom. And for popular sovereignty to work, education must always underscore and never undermine our common civic identity. Education should instill in children a respect for American self-government and the tools to achieve it, to equip students not just academically, but civically. But going back in the mission and the vision statements of the 100 largest school districts in America, the word America appeared exactly 0 times. But schools shouldn't bear the full burden. I think judges play a role too. And as Chief Justice Roberts put it, he said, civic education, like all education, is a continuing enterprise and conversation. And judges, by virtue of their judicial responsibilities, are necessarily engaged in civics education. We explain our reasoning in written opinions. We lead naturalization ceremonies. We oversee mock legal proceedings, and we speak at school events. This past March, the Judicial Conference of the United States affirmed that civics education is a core component of judicial service. And the Administrative Office of U.S. Courts has developed some really terrific online resources for judges and teachers and attorneys and parents. And as for attorneys, which many of you are uniquely equipped to help. And the public spiritedness of lawyers has always been this defining feature of America. I mean, lawyers have played major roles in some of our most triumphant chapters. So 25 out of 56 signers of the Declaration were lawyers. 33 out of 55 delegates to the Constitutional Convention. 22 of 39 signers of the Constitution. More than half our nation's presidents. The legal profession, as Justice Brandeis put it 116 years ago, it does afford unusual opportunities for usefulness, as he put it, that are probably unequaled. He says there is a call upon the legal profession to do a great work for this country. Lawyers, they are vital community connectors and civic switchboards. And the profession may well be different today than it was in 1904, but the calling of lawyers to public spiritedness and to robust citizenship endures. So I'll wrap up with this. At Disney World a few years ago, my children were mortified in the Hall of Presidents when I yelled out, "Woohoo!" for animatronic Calvin Coolidge. There he is. But Silent Cal, he understood the ineffable genius of what happened 233 years ago today. To live under the American Constitution is the greatest political privilege that was ever accorded to the human race. But a republic comes with responsibility. Self-government is not self-perpetuating. It's tough sledding, and each generation must take its turn. But this raucous republic, it belongs to all of us. And its preservation is up to all of us. Franklin told Mrs. Powell, if you can keep it. And a quarter of a millennium later, with every tool laid at our feet, there is no longer a question of capability. There's only a question of culpability. America, we boast the oldest written national constitution on earth. What an extravagant blessing. But preserving that rich inheritance requires a culture that prizes liberty, that prizes public-spirited virtue. For now, we the people are, and through God's grace will remain, the world's oldest constitutional republic, if we can keep it. Thank you very much, Ilya. That's all I have for you.
All right, well, we can't really hear anybody, but I'm going to applaud. So that was superb. And really, it's the exception to my general rule that PowerPoint is unconstitutional, at least as applied in 90% of cases. No offense to other panelists earlier in the conference that used it, but that is a wonderful, wonderful use of the medium. Brings to mind, we had P.G. O'Rourke giving a lunch book talk earlier this week, and I think you're giving him a run for his money as a constitutional satirist. I think we know what your next writing project ought to be, both for the middle school set and for the general public. It also reminds me, that depressing statistic about the naturalization quiz, which I took about 6.5 years ago, 7 years ago now, and yeah, I passed it. I'm not exactly the target audience, not exactly the normal person who's the average person who's naturalizing, but it was exceedingly easy. Name a country that borders the United States to the north. Who was our first president, given multiple choices? Name one of the three branches. Those, seriously, the universe of questions on geography, history, civics, that is the nature of the closed 100-question set, of which you are asked up to 10 questions that you have to get 6 right. That is how you pass the naturalization quiz. To see that only 5% of high schoolers, I'm just one of the, like most immigrants, I do a job that most native-born Americans won't, and that's defending the Constitution. But the rest of us, your presentation was funny and it was apt and it was driving the points home, but it's depressing, right? Because it seems like by the evidence that you presented, we're not keeping the republic. What should we do? Should we broadcast you all over the world? Should we, is it a question of improving education? Is it just a question of will? Ultimately, how do we do this?
Yeah, I don't know if I've cracked the code. It's kind of like judicial selection. I think every mechanism has pros and cons, but I think part of it is traceable to the fact that I think our educational system has largely moved to one focused on equipping students as they see it to make them kind of career ready, college ready. And there's a lot of testing that goes on in our public school systems. And what gets measured is what gets done. And so I think there's a really acute focus on core academic subjects. And I think that has had the effect of kind of crowding out the focus on civics education. I don't know when that phenomenon began, but I think certainly just the nature of our system and how it's more focused today on kind of core academic subjects and equipping people for college and for careers. I think maybe civics is viewed as kind of a soft subject that people can perhaps pick up at home or kind of pick up through osmosis. But it's just not a priority anymore. And I think we see the effects. We see the effects with how people misperceive, certainly my branch of government, Article 3. There's a kind of this widespread, bogus view that we're simply another kind of raw craven political branch of government, kind of force-feeding our will upon people. So I think it manifests in countless ways. But you look at these numbers year after year, 51% this year is the high watermark for the last 15 or 20 for as long as that survey has been going on. And 39% was the all-time high, which was last year. So I guess there is a measure of kind of really faint optimism, but I don't know if all that is just sort of a result of kind of the confluence of things kind of percolating in Washington with enhanced attention paid to whether it's impeachment and seeing how the branches of government sort of all come together. You got pandemic, you got recession, you've got all this unrest. So I don't know if that has sort of galvanized and captured people's attention. But certainly lawyers, as I mentioned, have a role, judges have a role, teachers, our school systems. Again, a lot of these students, they just don't get a lot of robust instruction on how American government allocates power. They don't get that around the kitchen table much anymore these days. And I think schools for a lot of kiddos is perhaps the only place where they might be exposed to the American political tradition, but it seems to have been crowded out by kind of a pedagogical focus on other subjects.
Well, we don't have any audience questions yet. I'll just remind everyone, if you're watching us on Facebook, Twitter, or YouTube, you can contact us at hashtag Cato SCOTUS, or just use the Q&A function in the Zoom browser. There is one interesting comment. Paul Marino says, sad but true, 143 years ago in 1877, James Garfield, our 20th president, gave a warning to the American people. Quote, now more than ever before, the people are responsible for the character of their Congress. If that body is ignorant, reckless, and corrupt, it's because the people tolerate ignorance, recklessness, and corruption. If it be intelligent, brave, and pure, it's because the people demand these high qualities to represent them in the national legislature. And then, of course, Garfield was shot. So, for what it's worth. While we build up some audience questions, I'll ask you a short one. What's your favorite Federalist paper and why is it number 51?
Is 51 the greatest paper or the greatest of all time? It is, I think 51, you know, if men were angels, no government would be necessary. One of my former law clerks, you may know this, but her firstborn, her baby, had a onesie that had that famous passage on the onesie.
Yeah, Josh Blackman gives those out. He says, the onesie says, I'm an angel, so no government is necessary.
I'm an angel, so no government is necessary. No, 51 is hard to beat. That sets a pretty high bar.
Let's see. Here's a question from Enrique. It says, what about Trump? Hasn't he done the most damage to our republic? Now, getting away from kind of the, topical things that'll get you in trouble with the Judicial Ethics Board, do you see the trends that you're describing as ebbing and flowing, or is it all going in one direction? Like, for example, the expansion of executive power just keeps growing and ratcheting up with each president. So is this kind of a, is it a zig and a zag, or is it something that you've seen over time? And if it's grown over time, I don't know how much you've looked at these various statistics. Do you date it to, our kind of cultural revolution of 1968, or the post-war era, or what historically in terms of trends, what's going on?
I mean, trends in terms of people's awareness of
civic engagement and awareness.
Work?
Yeah.
I think things have always been sort of partisan in America. People talk in kind of nostalgic terms about how this may be sort of the most polarized and kind of viciously partisan era. And things were not exactly patty cake in previous generations either. But there is something kind of, I think, maybe perhaps unique about our current era. We kind of have I think everything's sort of amplified by social media, certainly by kind of a journalistic community that seems focused on horse races and not kind of maybe a lot of in-depth kind of policy substance. Everything is kind of measured by clicks these days and what generates clicks, and it's well accentuating the fighting and the bickering and kind of how raucous and rancorous things are. You mentioned my Twitter feed earlier. I once thought when I first landed on the federal bench that I would give it maybe 6 months to a year and then perhaps I would come back. But the longer I'm away, the more convinced I am that I won't. And I'm still kind of lurking on Twitter. I still it's how I stay abreast of all the warp speed happenings in the world. And it really is neat to kind of follow a pretty riveting cross-section of people from various walks of life. It can be an echo chamber if you follow only those people who kind of reinforce your already held beliefs. But it is a way for information to ricochet in really fruitful, interesting ways. But it really is my primary news feed. It's how I stay on top of everything going on in the world. But I can't imagine coming back. It is a sort of dystopian, kind of toxic hellscape in many ways. And I'm happy to kind of lurk from a safe distance and follow who I want to follow. But the idea of kind of tiptoeing back, putting on my hazmat suit and tiptoeing back into the social media world is vicious. But it really was kind of a burden lifted when I stepped away, because it took energy, it took time to generate content and try to be interesting and engaging. And I think people were really astonished that a fuddy-duddy kind of bow tie wearing jurist can step out from behind the bench and come across halfway normal or interesting. And but the forced concision of Twitter is tough to master. It doesn't allow for a lot of nuance, and things are very kind of serrated. And I think that serrated nature certainly carries over outside social media to kind of media in general. And we all kind of hunker down in our respective kind of echo chambers. We watch only those news channels that kind of reinforce our already held views. We listen only to those podcasts or only to those commentators, only those op-ed writers who kind of pat us on the back and kind of serve more as a tailwind, that we're not really confronted or challenged to think differently. And things seem to be especially kind of serrated in this modern age. And I think a lot of young people are tuned out completely. They don't want to put on a red jersey or a blue jersey. There was a recent survey that showed however disengaged American adults are, it is even more magnified among younger people under 18. And the one and only area where they were more civically engaged than their adult peers was expressing their opinions on the internet. So, go figure.
Well, I most miss the "we will it" memes about your kids. I wish I could be off Twitter. I don't think Cato's PR department would appreciate that, nor my publisher, because I have a book coming out next week, Supreme Disorder: Judicial Nominations and the Politics of America's High School. Now. What's my book plate?
I said, get your book plate now.
That's exactly right. You buy it, I'll send you a signed book plate, because we can't do these in-person signings. But listen, a number of people have asked. They say your presentation is superb, which I think there's a majority opinion on that, no question. And they're asking, can we use it for my kids' classes and all this? And I'll just note, this will be available on Cato's website for public consumption within 24 hours. And the text of it, which will be less exciting and without the PowerPoint slides, although we might put in a few of the slides, will be in next year's Cato Supreme Court review. Here's a question from Philip Lammy, who says, do we know how homeschool children are performing on the civics test or generally on civics?
interesting. I've never seen data broken down by that. That would be fascinating to know. I know I've been invited by a number of kind of homeschool organizations and clusters and groups in the Austin area to come and speak to them. And I always happily and graciously accept. I want to go and kind of try to up our civics IQ wherever I can to kind of up our collective game. So I get a lot of invitations from homeschooling organizations and parents, and I uniformly accept them. And they seem very kind of on the edge of their seat, very engaged, very inquisitive, asking really hard, difficult questions. So I've never seen data broken down by that, by sort of the school setting, but I'd be really interested to know what it is.
Here's a question from Roger Pallon, who hired me and set me up in this wonderful civics education gig that I have. He says, a magnificent lecture. You've just pointed to the problem on modern lower education. What about the legal academy, where the agenda so often runs contrary to the principles you've so eloquently presented?
I mean, as I mentioned, I think the legal profession also has a key role to play, and it shouldn't really be kind of captive or hijacked by partisanship. Heaven knows lawyers kind of run the gamut. There's enormous ideological kind of diversity among the legal profession. That's no surprise, but helping people sort of learn about our founding principles and how our Constitution allocates governing power shouldn't be one of those issues that is just hijacked for partisan gain. I mean, I think Justice O'Connor, God bless her, has garnered well-earned kind of bipartisan praise for her efforts to boost our collective civics knowledge. I mean, this is all rudimentary stuff. And it's one thing not to know, the year the Constitution was signed in Philadelphia, but it's one thing not to know sort of these dry factoids, like how many of the signers were lawyers. But it's petrifying that so many of our fellow citizens, they flub even the most foundational, elemental, building block architectural features like checks and balances and separation of powers. That kind of fundamental knowledge, isn't blue innately, isn't red innately. That's just kind of red, white, and blue. That's just innately American stuff to know. And so I don't see how teaching people, teaching civic virtue and self-government ought to be a partisan issue. I think lawyers, as I said, given their unique roles in America, how they kind of patch people together, they serve as the kind of civic connectors. I think they're uniquely positioned, but also uniquely trained to know how our government works. I'm about to kind of put on my scratchy colonial costume again and go back over and hang out with the fifth graders. I thought about, I usually recite the Declaration on the scroll, and I'll probably do that again, but I'm thinking of doing a rap this year. So I may put together some kind of hip hop version, which I think might resonate a little bit more with them. But some of the materials that the Administrative Office of U.S. Courts is putting together, they are very teen relevant. They're not dry and just kind of yawn inspiring. They really try to be kind of current and kind of teen relevant. I think they've done a really good job with it.
Well, Trevor has offered in the chat to write the beats, so please do the rap. Perhaps it would be a sequel to Hamilton. I know Anastasia is a huge fan of that, so we would be very supportive there. You heard it here first, folks, and I'm afraid that'll have to wrap it. I know we have a bunch of late breaking questions. I would have asked them if you'd asked them earlier, folks, but we have to, you can continue the discussion over Twitter, where Don is a lurker, as he said. But you also see why he was my #1 pick in the fantasy judges draft. I, of course, am in a PPS league. That's the puns per sentence. And so there you go. I'll now, let's all just thank Judge Willett, because just a tremendous performance. So, my clapping will have to stand in for the masses. Well, I now invite all of you to have a reception in the comfort of your own home. It's raining in Washington anyway, so we wouldn't be on the roof deck. It would have been some cramped indoor facility anyway. But next year is the 20th Cato Constitution Day Conference and Supreme Court review. So we'll have to, given the money saved this year, we'll have to have double the food, double the booze, and double the liberty. Thanks very much, everyone.